and more specifically the Eskdalemuir Seismic Array, in relation to the application for consent for a wind farm at Greystone, Knowe, which would comprise 14 wind turbines and associated works. The site is located to the south-southwest of the village of Heriot and west of the A7. Today's session is a hearing session. We'll follow the rule. I'd like to begin by taking a note of the part. With the applicant, please, Mr. Trinick.
Thank you, ma'am. Good morning. Marcus Trinick, Solicitor of King's Counsel, instructed by Amy Howard to my right, Wright Johnson Mackenzie. Amy and I will be doing the session together. To my left is James Mansfield of the project company Coriolis. To Amy Howard's right is Alison Sidgwick, who you know, and beyond that, Lynn Sweeney, and can't see down the line, Fraser Gillis, and Matthew Cant, who you'll see this afternoon. Thank you.
Thanks, Mr. Trinick. Ms. Crawford, could I ask you to introduce your team for today?
Good morning, ma'am. My name is Ruth Crawford, King's Counsel. I'm instructed by Morton Fraser McRoberts, who act for the Ministry of Defence. To my immediate left is Mr. Douglas Milne, who's assisted by his colleague, Mr. Douglas Harvey, both from Morton Fraser McRoberts. And I imagine that this morning's session will be conducted primarily by myself and by Mr. Milne. To my right is Mr. Desmond Egan, who is from the Defence Infrastructure Organisation, who may, if required, be able to assist the inquiry with the current position of the MOD relative to its safeguarding approach for the Eskdalemuir Seismic Array. Behind me, again, are various individuals, including Mr. Fraser Littlejohn, who you heard from yesterday. But it may also be of note, ma'am, to see that Dr. David Bowers, who is the technical expert relative to the protection of the array, is also here, should there be any technical questions which arise, not least in relation to what work may or may not be required and what work is ongoing relative to developing science, if I can shorthand it that way. Thank you.
Thank you very much, Ms. Crawford. I have explained previously at the beginning of each session what the purpose of this is. I think you're all familiar with it, so I won't repeat myself this morning. For the purpose of the webcast, you should be aware that the webcast of this morning's session and all other sessions will be recorded and stored as part of our webcast archive and will be capable of the public. By participating in these sessions, you would consent to being filmed and to the use and storage of the images and sound recordings for webcasting and training purposes, and for the purpose of keeping historical records and for making those records available to the public. If you wish to have any further detail on that, it is available on our website. For those following online and for those in the room, the general structure of today will follow the agenda that I have already issued in relation to this specific session. It will be this brief introduction, and then we will move into the draft conditions document very briefly, and then we will move on to specifically conditions 6 and conditions 12. I have a number of questions to ask, and I imagine the discussion will not range too far in its scope beyond Eskdalemuir. In terms of process after this, following this hearing session, we are holding an inquiry session into noise, which will be the last session of this entire inquiry process. We held the community hearing session last night. Quite a few of you in the room attended. That, should you not have attended, that is available to view on the webcast. There are no matters arising from that hearing that need to be addressed today. I will mention summaries of case again. very helpful if that could form part of the parties' closing statements. We can organise for a template to be forwarded from the office to you. It is helpful if that template can be used, mainly for my benefit rather than your own, but it does assist. Some brief housekeeping matters today. There is no fire alarm, so if the fire alarm does sound, it is a fire alarm. The fire escape is back to the main reception, down the main stairs to the front of the building. If that route is not available to us, please turn right and then immediate left out of this room. There is the facility to order lunch. There is a form somewhere in the room. That can either be collected in the dining room, or there are tables set aside for people to sit and have lunch in the dining room. Toilet facilities are directly opposite. I don't think there are any other housekeeping matters to discuss. So I think we can move directly to my agenda. Is everybody content? Yes. So that was item 1. Item 2 is draft conditions. The CD number I had noted on the agenda is 16.4. I think there is an updated version of that.
That's correct, ma'am.
Yeah.
And that's been lodged as CD 16.7.
So parties could note that. I'm content that the questions I had regarding conditions other than 6 and 12 are now addressed. The only one I would like to note is condition 15, which is ecological clerk of works, and that is a matter which has been raised in writing by Racial Farms Limited about requiring a monthly update. There's no need to discuss it. I've noted the positions, but just to let you know, that's not agreed by Racial Farms, but is agreed between Scottish Borders Council and the applicant. So that is noted, and thank you for the submissions from Racial Farms. So, moving swiftly to item...
Sorry, can I raise a matter with you? I'm not quite sure what the agreed status of the draft noise condition is at the present time, but can I underline that Heriot Community Council is not in agreement with the draft? And the witness will speak to that this afternoon. I don't want to elaborate now, but just for your notes, that's still a live issue as between my clients and the applicants.
Yes, I hadn't intended addressing noise at all this morning, but I do note your position on the draft conditions.
No, I don't want to address the substance, it's just on the draft condition. And also, thank you to Ms Howard for circulating 16.7. It's not online yet, so if anybody's watching from outside, they can't see it.
It should be online later this morning. Our office have emailed to tell me that there is a slight technical issue in our office, and no uploads to our case management system will happen until later this morning. So it will be available, but I think all parties have it in the room.
We're just checking just now, and it appears to have gone up. Yeah.
That's thanks to our very efficient case officer, Christine, who clearly popped it on. So that is good. Is noted, Mr. Campbell. Thank you.
Thank you, ma'am.
So, moving to item 3, which is conditions 6 and conditions 12 in the draft conditions. Condition 6 relates specifically to Eskdalemuir Seismic Array, and condition 12 relates to micrositing, which is again of concern to the Ministry of Defence. Those are the two primary conditions that we will be discussing. They are of most relevance to the MOD's position on Eskdalemuir. I'd hoped to start with an update on the position in relation to potential technical solutions. I do note the documentation submitted by the parties in relation to the most up-to-date position in terms of timing and instruction of work packages, but it would be useful for my notes and for everybody in the room to hear the most up-to-date position. I think probably best coming from the MOD to begin with, and then perhaps the applicant can confirm that that is also their understanding.
Thank you, ma'am, if I can assist with this question. I think it is important to understand that there are a number of work streams being undertaken in relation to the seismic array. So, first of all, there is work that MOD is doing in relation to its policy, and I'll not speak further about that just now. The Eskdalemuir Working Group is also taking forward a number of work packages, and that's what I will focus on in this answer. Those work packages, it is anticipated, will inform policy which will be developed by the Scottish Government, and I'll not comment on that further at this point in time. So, going back to the work packages, and as a late document by the applicant. MOD has been collaborating with industry, with the Scottish Government, through the Eskdalemuir Working Group. It has been quite progressing matters through that forum, and the appropriate place to progress. Were identified through the need for these work packages was identified through Dr. Bowers of the Atomic Weapons Establishment sitting behind us, and members of the Eskdalemuir Working Group. The work packages were identified some number of months ago, and it's only recently that the MOD has been informed that those packages, progressing them, has been commissioned. I think I can comment on behalf of the MOD that they do consider the timescales on the Gantt chart to be ambitious, and maybe say nothing more than that. Other than that, in the MOD's experience, matters in relation to the array do seem to take a considerable period of time to progress in terms of evolving understanding and potential policy solutions. The MOD can't comment on what the AIFCL has done by way of commissioning these work packages and what timescales are likely to materialise. But the key point that we would like to emphasise is that although the work packages were identified by Dr. Bowers in discussion with the Eskdalemuir Working Group, it is not necessarily anticipated that on those work packages being completed, that will give rise to a resolution. There is every possibility that the work packages will identify further work packages. We don't know, and that's really the key point that I wanted to make on behalf of the MOD in relation to these work packages, this technical work. I hope that's of assistance.
Yes, it is.
Sorry, Ma'am, I wonder if I might just add to Mr Milne's comments, just by way of illustration as to the amount of work involved. And I'm afraid I don't have the CD number, but we were helpfully provided a day or so ago with the redacted contract. And I don't know, ma'am, if you have that available. And this is really just by way of illustration, because I would invite you, ma'am, to have a look, for example, at Work Package 2, and a bit of information is provided at section 3.2 of that document, which I have on a PDF starting at page 27. And it's just to try and illustrate the scope of the work which is required. And this is just work package 2, which is addressing preconditions required by the MOD to allow final MOD verification of phase 4 and phase 5. Pausing there, the inquiry may have picked up that there was earlier work done by Xi Engineering relative to what's described as phase 4 and phase 5. And one can see, looking at the various points, 6 listed there, that there is highly technical work required relative to agreement validation of turbine source models, rotor diameters, etc., value of SIL, that's seismic impact limit, which is something which is currently being considered by the Scottish Government to be agreed, concept of various characters, values to be agreed, and so on. And there's further consideration given, for example, if we look to the categories A, B and C set out at section 3.2.2. And I needn't take up time in this session, but simply to illustrate, just by looking at work package 2 alone, that this isn't a simple exercise of sitting down and doing number crunching. Thank you, ma'am.
Thank you. Better. I think it is, actually. Thank you. Engineering and you might, do they work in collaboration with the various parties within the MOD in carrying out these work packages, or is it a discretion by a separate company? I was slightly unclear as to how it actually worked in delivering the work packages.
Ma'am, we refer to them as Xi. I think you're correct, but I'll find it difficult to refer to them differently. Xi are an independent company. They're not related to, they're not contracted to the Ministry of Defence in any way, but the MOD is aware that the Eskdalemuir Working Group has contracted Xi to undertake certain work. In terms of collaboration, Dr. Bowers, when reviewing Xi work on behalf of the MOD, does provide comment to the Eskdalemuir Working Group and to Xi. So it's a good working relationship, but there isn't a contractual link in any way. The work's not done on behalf of the MOD.
Okay, thank you.
Ma'am, I do think, if I may, it is helpful to emphasise, as Ms Crawford was explaining, that although some of the applicants' evidence might suggest that what is required is for the MOD to, or for Dr. Bowers to review and approve the Phase 4 and Phase 5 work, that it's not a case that Dr. Bowers has not got round to doing that. Dr. Bowers has reviewed that work, and it has given rise to the further questions, which has informed the content of the work packages. And as I've explained, the MOD would not be surprised if the work packages actually gave rise, on review by Dr. Bowers, to further work.
Would it be an open generalisation to say that the experience via the work resulting in further work?
Ma'am, I really don't wish to be facetious, but it may be that the past 15 or 20 years has demonstrated that that is the case.
And again, maybe difficult to, but you did say that you felt that the timeframes anticipated in the work packages and in the table provided by the applicant were ambitious. How ambitious? Unachievably ambitious, or potentially, if we think about things?
Although the MOD, and I emphasise this again, is committed to working with industry through the Eskdalemuir Working Group to find a solution, in terms of your question about ambitious, the reality is that nobody knows or can know how long this will take.
Thank you. To see if you want to make on that question.
Yes, thank you, ma'am. You might want to compare page 3 of the applicant's hearing statement, which sets out the steps that we say need to be achieved, with what's in the contract which has been provided. The contract has been admitted to the inquiry, actually following a request by Mr. Campbell that it should be admitted, and we're perfectly happy to produce it. I don't want to go into huge detail about the contract, but take you to one or two key passages. Ms. Crawford is quite right to take you to, is it page, the Schedule 5 anyway, the ZI engineering proposal, and within that there's a paragraph 1, required work, and that lists the work packages. Just relating, for your benefit, what is there to what is in the, on page 3 of the applicant's hearing statement. Work package 1 would appear to equate or relate to step B, set out on page 3. Work package 2 broadly represents step A. Work package 3 is not actually listed in the hearing statement. Work package 4 is step C. Work package 5 is step D. And work package 6 is step F. So that relates the hearing statement to the contract in I hope a helpful way. So far as the work packages are concerned, if you turn over 3 pages, apologies, 2 pages, you can see then the work packages described in more detail. I'm not going to go into that detail. Ms. Crawford has very accurately taken you to the complexities of work package 2. We don't pretend the work required is not complex. There's a lot of work to be done. Work package 3 is on the next page. I'm not making any comment on that, nor on the work packages which follow. They're reasonably self-explanatory. Mr. Milne referred to the last 15 or 20 years. I think that hides some key events which punctuated those years. One was 2014, when the present predictive algorithm was adopted, approved by the MOD and adopted. That allowed further developments to take place, and that continued until another milestone, which was 2018, when, shall we say, the gate closed on new development because a project proposed breached the ceiling, and you would read references to 0.336 nanometers, that's the ceiling. It's since 2018, really, that so much work has been done through the EWG to try and resolve the issues. So we're really talking about the last 6 years of continuous effort to try and resolve it. It does take a long time. I'm not pretending it doesn't. I'm sure that the MOD, noting paragraph 448 of its hearing statement, will confirm that its support for renewable energy targets and respect for the Scottish Minister's policy on renewables will mean that it will do its utmost in the shortest time possible to enable further onshore wind development to take place within the zone. But I have to agree with Mr. Milne that nobody can know when that work will be complete. I can't sit here and tell you. I would love to be optimistic. I'm not going to be. It's not my job to give that type of evidence. I cannot tell you when that work will be complete. I can't tell you when additional headroom might become available for new development. I can't tell you that it will be available within 5 years. We hope it will be. I trust it will be, but I can't tell you it will be within 5 years of the life of a Greystone Knowe consent. But for a reason I'll expand on later, and we will come to that in the agenda, that is absolutely not fatal to the prospects of imposing a suspensive condition. I think there is evidence before you based on the Scottish Minister's determination to resolve the Eskdalemuir problem of the industry and for the MOD expressed in the onshore wind sector deal, and based on the work of the onshore wind task force, the UK task force, which has an aviation defence subgroup, part of whose remit is to consider Eskdalemuir, based also on the very recent award of the contract for the work packages. I think there is evidence that progress will be made rather faster than has been made in the past. I hope that we'll see the release of headroom well within the lifetime of any Greystone Knowe consent, but that is as far as I can go. I think that completes what I want to say on that topic.
Thank you, Mr. Trinick. Does the MOD have any further comment on that topic before we move on?
Ma'am, I think it would be appropriate, just picking up one of Mr. Trinick's comments, that of course the MOD will continue to work with the Eskdalemuir Working Group and the Scottish Government. It has done in the past, it is doing so at present, and I am able to say that it will continue to do so in the future. However, it should be made clear that the MOD will not confirm whether headroom can be released, and that's yet to be known, unless and until all the work has been done to its satisfaction. And of course the reason for that is founded, as is not disputed, in the international importance of the array and the work that it requires to do. And that being so, the MOD will not remove its objections to current and future developments which have not been consented, which, as presently advised, cannot be accommodated within the existing headroom. As I say, of course the MOD will continue to cooperate to see if headroom can be released, but until it is satisfied on that crucial question, it will continue to object to development within the consultation zone. Thank you.
Right. Thank you, Ms. Crawford. I think we have, in both your answers to my question, covered the next bullet point, which was the remaining steps to be completed. And we have, I think, had a discussion on timings and assumed timings as far as we can discuss that in this forum. So I am going to move to my next point. I was hoping to have an update on the Ministry of Defence's consultation process and your approach to capacity and timeline for publishing your new approach post the consultation process, which has just ended.
Thank you, ma'am. In my answer to the first question, I explained that there were a number of different work streams, and the first one I mentioned was this one, the MOD consultation process, and it is important to understand that that is separate, does not rely upon the policy work of the Scottish Government and the XI work packages. The MOD's consultation process has focused on the order in which it, in common language, allocates budget to developments. The MOD undertook to the Court of Session in the petition for judicial review, which you will have read about in the evidence, into its original process for managing the Eskdalemuir budget, to undertake a consultation, and it has now done so. That consultation process, as you've noted in the agenda, ended December 2024, and the MOD is currently considering the responses that it has received. There is a further work stream being undertaken in terms of auditing the existing baseline, and I'm sure we will talk about that later. What the MOD is anticipating doing at some point later this year, likely the middle of the year, is publish its new approach along with an audited baseline. It is important to understand that the MOD does not anticipate that the process that it's going through, considering consultation responses, publishing a new approach and an audited baseline, will in itself release any headroom. Now, it may be asked, why is the MOD doing this? And that's why I explained a lawful approach is an appropriate thing to have in place, and that will be necessary in order to facilitate the operation, it is assumed, of any approach that the Scottish Government puts in place. The MOD's sole concern is to ensure that the threshold is not exceeded. Its policy remit, of course, is not maximising renewable energy development within the consultation zone. That is what the Scottish Government's approach will be focusing on.
Thank you, Mr. Milne. Could I ask the person who's sitting closest, which would be you, to close that curtain for me? Thank you very much. Right, I can see you all again. So, would it be reasonable to summarise the Ministry of Defence's position in terms of publishing your new approach, in that it will set the context within which you would choose to make objections or otherwise to decisions within the zone for wind turbines, but those decisions will be contingent on the work packages being completed and the findings of the working group and ultimately Scottish Government policy?
Ma'am, there may be a degree of confusion here, for which I apologise. The work which, the consultation which the MOD has carried out and the approach which it is consulting upon is to enable it to manage applications for either Section 36 consent or town and country planning permission for wind farm development within the consultation zone. Clearly, the MOD does not address the merits of any such application. That's not its role. It has, we know, the existing headroom, the threshold as it's sometimes described, and thus far, that headroom has now been exhausted, as Mr. Trinick explained. It was exhausted in 2018. The previous approach was a first-come, first-served approach. So first-come, first-served was by date, and again, this is where it was challenged, was by date if it was a Section 36 consent, if there'd been a screening application, but if it was a town and country planning application, then it was the date on which intimation was made to the MOD of the application, and that was declared to be unlawful. There was no rational basis for that. The consultation invited responses as to whether there should be a simple, straightforward first-come, first approach, i.e. applications, whether under the Electricity Act or under the Town and Country Planning Act, should all be treated equally and would be placed in the order in which they were intimated to the MOD. That approach, once the MOD has considered the responses, will be published, and developers will know the order in which the MOD will consider what headroom, if any, sorry, that's the wrong way, the order in which the MOD will consider their application against what, if any, headroom remains at that time. Now, clearly that question, what, if any, headroom remains at the time, is that which is being addressed by reference, amongst other things, to the various work packages. I'm not sure if that makes it a bit clearer.
No, it does, and that is my understanding. Mr. Trinick, do you have anything to add?
What's been said is entirely accurate. I have no quarrel with it. Just correcting one point, I don't think it's at all important, but the approach which was judicially reviewed was one which gave undue preference perhaps to Section 36 applications, but at scoping stage, not screening, I think. That's all right, it's a very small point. I think what has been said also points up the approaches of the Scottish Government and the MOD. As I understand it, I'll be corrected if I put this in too simplistic a way, the MOD's sole role in life here is to safeguard the array. And it does so by means of its approach to managing development. The Scottish Government's role is to optimise, I would call it, not maximise, but to optimise development within the zone. And it does that through its approach to such matters as the extent of the exclusion zone and perhaps the seismic impact limit. But that's in the future. We need to talk about that. There are distinct roles here, one for the MOD and one for the Scottish Government.
And I can just say that that's entirely correct and no issue is taken with that latter. Mr. Trinick suggests it might be simplistic, but that latter characterisation of matters.
Right, thank you all. If there's no further comment on that point, I will move to my next bullet point on the agenda, which I would like to hear from each of you about the use of suspensive conditions generally, and both of you have provided examples in your statements, particularly the applicant, in relation to the use of suspensive conditions in other cases and other circumstances. If we could go to your position on suspensive conditions rather than the specific suspensive condition proposed in this instance. And I'm going to start with the applicant. Thank you, Mr. Trinick.
Thank you, ma'am. I can be quite brief because I'm not addressing Greystone now here. I'm looking at the use of suspensive conditions generally. And I can be very brief because we've set out our position in hearing statement, paragraphs 18 to 22. I'm happy to answer any points, but nothing particular to add because it was set out there with reasonable thoroughness. I do note that although it purports to do so in paragraph 5.6 to 5.12 of its hearing statement, the MOD has actually not addressed the specific tests of the validity of planning conditions as set out in Circular 4 of 1998. So I'm going to leave matters there and respond as necessary to what the MOD may have to say about that, about suspensive conditions generally, having regard to what we've already said in our hearing statement. Thank you, ma'am.
Thank you, Mr. Trinick. Ms. Crawford.
Thank you, ma'am. First of all, by way of suspensive conditions in the past, so far as the seismic array is concerned, I make the general point that a few applications have been granted subject to a suspensive condition. The context, as always, is important, and I think, ma'am, the inquiry does have evidence of the cases where suspensive conditions have been granted, but it will be noted from those that they've been granted where, as is conventional, the applicant has offered mitigation, namely to reduce the seismic ground vibration, which is a fairly classic use of a suspensive condition. And so far as negative suspensive conditions are concerned, of course, the paradigm example is the case of Grampian Regional Council, which the inquiry has a copy of the authority itself. And there, as we all know, the suspensive condition was a means to address a traffic hazard. And the means in that case was to have the particular road stopped. And there's no objection, of course, in principle with such a suspensive condition if there is an adverse impact on a resource, using a neutral term, and if there is a means to remove that resource, then it may be appropriate for the decision maker to grant permission or consent, as the case may be, subject to that adverse impact being removed. That's as a generality. What a suspensive condition seeks to do is to remove an impact which would prevent an otherwise acceptable development taking place. Here, and I know we'll go on to discuss it in more detail, but I just flag up it just now. Here, the condition proposed by the applicant is, in our submission, extremely unusual. And it amounts not to the a means or a mechanism by which to remove an adverse impact. Rather, and one can characterize it various ways, but at one level it could be said to be a means by which to, not even a means, but it simply seeks removal of an objection, that being the objection of the MOD. But of course the means by which that is to be achieved, comparing and contrasting, for example, Grampian, the means by which that is to be achieved are not known other than by reference to rolling one's sleeves up, mixing my metaphors, digging in the weeds of the work packages. So, of course, we all know when suspensive conditions are appropriate. This is not a conventional suspensive condition by any means. And there are also, and again we'll come on, I'll just flag this up at this stage, in terms of how such a suspensive condition would operate, how that in practice would work when one considers the considerable number of applications of which this inquiry will be aware for renewable development within the consultation zone, some of which predate Greystone now, so far as when they were first brought to the MOD's attention and the MOD was consulted upon. And there are others, of course, post-dating Greystone now. And the inquiry has heard evidence about the approach, the first-come, first-served approach, and the future approach, which obviously I'm not going to write the MOD's approach here and now, but the consultation was to have a more simple, if I might put it this way, first come, first served approach. So just to outline the position generally on the part of the MOD, it is well understood that suspensive conditions can be an appropriate way to remove an obstacle for an otherwise acceptable development. This is not a conventional suspensive condition.
Thank you, Ms. Crawford. Mr. Trinick.
This topic wasn't Greystone now, it was the use of suspensive conditions generally. And I've still not heard anything from the MOD on why, on the tests in the circular. Maybe there's nothing between us, but and we maybe come on to those tests when we discuss the Greystone now condition in detail. Certainly I think we need to do so. We can do it under the next agenda item.
Are you referring to the paragraph in the MOD hearing statement? I think it's
5.6.
Yeah.
Yes.
And then are you saying that you consider that after paragraph 5.6 there isn't actually a discussion of the tests?
I'm suggesting exactly that.
Okay. Right. Well,
We can come on to it under 5, but as long as we do tackle
yes.
that particular topic, because the reason I say that, ma'am, is that adopting planning principles, noting the British Railways Board case, the legal foundation in terms of reasonable prospects tests, and then applying the circular, that's the basis of our argument. We are in a conditions session. We need to deal with that in detail. I've got notes on that in paragraph 5, which I will come to. But this item was simply about the use of suspensive conditions generally. On that basis, I've got no more to say, and let's wait for item 5.
Okay. Ms. Crawford, you've heard Mr. Trinick's comments. We will address that matter, I think, further on in the agenda rather than here.
I think that is appropriate because I think all parties recognise when suspensive conditions are appropriate, and I hope I've indicated the MOD's position on that, but I also said context is important, and it's a bit difficult to address rooting them into an actual proposed, as I've said, by way of introduction to looking at condition 6, it is very unusual. And yes, it is true one hasn't gone through line by line in the hearing statement the tests and the planning circular rooted in the case law. That's because, frankly, it's impossible or very difficult to do so when one comes to analyse exactly what is proposed by condition 6.
Okay. Well, we can have a full discussion on that specific matter later in the agenda. I'm content that I understand the parties' positions on the general application of suspensive conditions. So we will move to the suspensive condition as proposed by the applicant. It's set out at paragraph 17, which is page 5 and 6 of the hearing statement. So, Mr. Trinick, could I ask you to begin there?
Yes, that's probably be my longest contribution, so I apologise in advance. The proposed condition is intended to work as follows. Let's see how it works first. Step 1, paragraph 1 of the condition, is to finalise the precise locations of all the turbines. The MOD absolutely needs this information in order to calculate or approve the calculation of the total seismic ground vibration of the development. Using this information, MOD will then respond to the Scottish Ministers under Part 2 on a request by the applicant to discharge Condition 6. That's how it works. But a number of matters need to be considered here, arising mainly but not wholly, from points made by the MOD. So if I may, I will go through them.
Yes.
So the dry atmosphere in this room is 3 days of it. Firstly, it's anticipated that Condition 6 would be imposed on the Section 36 consent, not the deemed planning permission. It could be imposed on the deemed planning permission, nothing wrong with that, but I have in mind from the MOD's point of view that if the discharge was refused under the planning permission, that would give rise to a right of appeal, whereas if the ministers refuse to discharge the condition, there is no right to go to court, but there's no right of appeal. Now, there are one or two possible responses from the MOD, yes or no. No judgments are required about the effectiveness of any mitigation, since none will be proposed, and the reason for that is that at a distance of 45.2 kilometres from the array, the seismic impact limit, and that can be explained if you wish, probably by Mr. Bowers, is better than to explain it than me, would not be engaged. In other words, this development, if there is headroom, will be able to proceed without mitigation. Now, since a yes or no answer based on information held by the MOD will be based on that, the applicant is content with no right of appeal. Indeed, the applicant will know the answer to the answer before asking the question. And that is because the MOD, as has always been the case since 2005, maintains a list of projects. Under the MOD consultation paper, the MOD will continue to maintain such a list of projects. Greystone now is already on the MOD's informal list, kept since 2005, and would have access to headroom, we use various words, budget, headroom, capacity, whatever, in accordance with the approach finally determined by the MOD following its consultation paper. And I refer you to paragraph 4 of that paper, noting the reference in paragraph 2 to the fact of an existing list. The headroom is proposed to be awarded on a first-come, first-served basis. That seems very fair. But that's first-come, first-served as at the date of the application, not at the date of the consent. As an aside in this context, I note that the MOD applied the same approach at the date that Greystone now was submitted, and so it appears on the MOD's informal list. Its position in the queue is fixed, and the grant of a consent would not change its position in the queue. It could not be preferred under that system to a project ahead of it in the queue because that project was submitted earlier than Greystone now. No leapfrogging. The precedence in the queue is according to the date of the application. Therefore, apart from the issue of the Section 36 scoping stage, which doesn't concern us today, what Condition 6 proposes totally accords with the MOD's past and proposed future approach to the safeguarding of the array. Either there will be headroom or there won't. It's a binary issue, so actually a right of appeal will be an empty benefit. And my second point is that the hearing statement of the applicant addresses all of the 6 circular 4 of 1998 tests in paragraph 18. I would imagine not more needs to be said about necessity, relevance to planning, or relevance to the development. So let's look at the other tests. The condition is clearly enforceable. A binary approach is required to a single question, and the detection of a breach would be rather simple. Ditto, both action required to remedy the breach, stop the development, and powers of further enforcement if required. They're there in the Act. In terms of precision, I hope that you find the wording of condition precise, the wording of that condition precise. Happy to answer any points on that. The final test is the most difficult one and probably engages us most in this discussion, and that is reasonableness in all respects. That test is discussed in paragraphs 33 to 39 of Circular 4 of 98. I've got the following points to make on this test as it applies to condition 6. Firstly, it's not unduly restrictive. It does what is necessary and no more. Secondly, it might be said that to grant permission subject to a condition that cannot in the event be discharged risks prejudice to other projects outside the Eskdalemuir zone, which could be refused only because of cumulative environmental effects, probably landscape and visual, possibly other, with the consented Greystone now. That argument doesn't hold any water. First of all, there are always reasons why a project may not proceed, if consented. Indeed, Mr. Kelly and Professor Hughes have pointed to a number of unimplemented planning permissions. Uncertainty is always there in planning. Uncertainty of implementation is always there. Secondly, the prejudice could only be to projects beyond the zone. That is why we produced a further version of KA1 with the boundary of Eskdalemuir shown. And a glance at that figure shows that beyond the zone to the east, relevant proposals, I'm sorry to refer to evidence which the MOD weren't here to hear.
Mr. Trinick, would it be helpful for parties to get KA1 in front of us?
It might possibly be, yes, okay, yes it would be.
The MOD, do you have a copy? That's Ms. Kelly Anderson's appendices.
You've got 2 hard copies I gave you yesterday.
Give me a moment.
Is that your version should be on A3 only? We've got a spare, unmarked spare here.
No, I beg your pardon. I didn't hand it to you yesterday.
Thank you, ma'am. If we look at this figure, first of all, I'll do what I should have done before going into it more. We can see Greystone now, the black dots. We can see there the red line is the boundary of the Eskdalemuir zone. That's taken from the further, so it's 45.2 kilometres, and so 4.8 kilometres from the turbine furthest from the zone, sorry, furthest from the red line to the red line. Whether that calculation is precisely correct, the MOD say we've done it the wrong way. It doesn't actually matter. The fact is we're in the zone, and we're either at 45.2 or we may be closer, but we're near the edge of the zone anyway. If you look beyond that zone to the east, and we can see Knowe wind farm there, that is an LCT, it's landscape character type 91, which we discovered in considerable detail during the landscape and visual session. We can see there are already 3 wind farms there, Knowe, its extension, Toddleburn, and Long Park. So the issue of cumulative effects already arises. And in any case, the minimum distance from Greystone now will be around 5 kilometres to the edge of the zone, so that any new project outside the zone would have some separation anyway already from Greystone now. Now, KA1 shows all operational, consented and in planning projects. I say as a matter of timing that where a project to come forward to scoping after today, and if Greystone now received a consent in, shall we say, late 2025, if it did, that new project would have to proceed pretty quickly to be prejudiced by Greystone now, because the application could not be made immediately. It would probably be made if it came forward now in about 2027. Probably wouldn't be determined until 2030. So I'm not sure that issue of prejudice arises. And to rub that home, I took Kelly Anderson in chief, you'll remember, to the issue of future projects. She confirmed by reference to KA1 that she had not found any in-planning or scoping stage projects which postdated those shown on KA1.
Just for clarity and for the benefit of the MOD, that was evidence discussed at the landscape and visual session, which was an inquiry session on Tuesday of this week.
Leaving that map now, my fourth point, as determined in the British Railways Board case, which is it's a core document and it's referred to in paragraph 19 of the hearing statement. If a suspensive condition is appropriate under sound planning principles, in other words, if the development proposed is acceptable, the fact that it appears to have no reasonable prospects of being discharged does not mean that the grant of a planning permission is unlawful. And we can see that paragraph 38 of Circular 4 of 1998 advises on the reasonable prospects of a condition being discharged on precisely the same basis as the British Railways Board case. So law and planning advice say the same thing. It's perfectly open to the Scottish ministers to make a policy advising that there should be reasonable prospects of achieving a discharge within the lifetime of a consent to justify the imposition of a suspensive condition. But none has been made for this topic. Eskdalemuir. And if you did decide to apply a reasonable prospects test, and I think I refer to your agenda here, you say in the third last bullet point, is there any certainty that the condition should be discharged? The test is not one of certainty, it is one of reasonable prospects. As I said earlier, there will be uncertainty about the implementation of permissions and other reasons why Greystone now might not be built. That's always a possibility. It's also necessary to compare the condition proposed here with other conditions put forward to address the array. And I refer to the hearing statement, paragraph 28 on this topic. So in summary, there were conditions proposed for Forside, Scoop Hill, which is current, Callister Hall, current application or appeal, and Little Hart Fell, a current appeal. Only Forside has been determined out of that list. All of those conditions require the approval put forward, require the approval of mitigation, with a requirement for further technical information to be submitted after the consent. In contrast, this applicant neither challenges the MOD objection nor proposes technical mitigation, which I think would be resisted. Indeed, it declares itself content to await the outcome of the current technical work under the auspices of the Eskdalemuir Working Group. It proposes a binary test, as discussed. In this context, I do draw attention to what the MOD said in its hearing statement at paragraph 26. Sorry, my apologies. It's in the context of the Little Hartfell appeal, the MOD confirmed that, I quote, the MOD does not oppose the use of suspensive conditions as a matter of principle. The MOD has been clear that its position is that the use of the suspensive condition in the context of this application appeal would prejudice the safeguarding array. That remains its position. Of course, that is not to prejudice the possible use of suspensive conditions in the future, where to do so would be appropriate. I think it's a very fair statement. So the question is, if there could be, my question anyway, no prejudice to by the for consent subject to the condition proposed, why would the MOD object to it? Prejudice to the array could arise. I've already outlined how the condition would work. The Scottish ministers must always be deemed to act reasonably. If the MOD refuses a request made under the condition, the answer from the Scottish ministers would be no. And the question to be asked is that which the MOD, using the 2014 predictive algorithm, has answered on many occasions. What is different now? If the MOD is to persuade you that prejudice to the array will arise, it must explain why the operation of a binary approach using the 2014 algorithm, and before that the 2005 algorithm, has not successfully protected the array. And it must explain why it's gone through a replacement algorithm, which will again operate on the first at the date of the application. Now, those are the comments I want to make. I'm sorry they're so long. This item, the item 5, the key of the agenda.
Thank you very much, Mr. Trinick. I'm looking at the time, and I think it's probably an appropriate point in proceedings to take a short break before we turn to the Ministry of Defence. It's 10:37. If we break and come back at 5 to 11. Thank you all. By the applicant at paragraph 17 of their hearing statement. Mr. Trinick had given us his comments on that. I'll move to the MOD now, and any questions I have, I will do at the end of their submissions. Ms. Crawford, could I ask you to begin?
Thank you, ma'am. I wonder if I might pick up shortly before Mr. Trinick concluded his comments by reference to the submission made by the MOD in the Little Hartfell appeal. And Mr. Trinick, in the statement for the applicant at paragraph 26, quotes from the MOD's written statement in Little Hartfell. The inquiry has that document at CD 16.3, and it might be useful, ma'am, if you were able to find that, just so that we can place the submission made at that time in its proper context.
Yep. Just one moment while I find my electronic version of that. Yes, I have it.
Thank you. The quote is taken from paragraph 3.8.
Just for clarity, that's page 4 of that document.
Yes.
Real page 4 as
Yes.
opposed to electronic page 5, I think.
Indeed. And you will see it stated there, the MOD has been clear that its position, etc., and that's the quote repeated in paragraph 26 of the applicant's statement before this inquiry. The inquiry will note, of course, the context in which that statement or its position was set out, and it's under reference to the onshore wind sector deal. And then reading down, scrolling down in my case, 3.9, the MOD does not have an in-principle objection to the use of suspensive conditions, etc. And the MOD has often agreed to the use of suspensive conditions in the context of military radar when technical mitigation has been proposed. As I outlined earlier in opening remarks, conventional use of suspensive conditions providing mitigation to remove adverse impacts, in this case in the context of military radar. The statement then goes on at 3.10 to referencing the sector deal and working collaboratively to finalise a new approach to seismic noise budget management and to develop new guidance to be issued for public consultation no later than January 2024. Well, we're a long time, we're a year now from there and we're still not seen it. Discussion about the appellant's views on reasonable prospects test. And again, the MOD's position on that is that this is misleading because of the work going on under the auspices of the Eskdalemuir working group. And then an explanation at 3.12 about that work, and in particular, the work being undertaken on behalf of the ministers regarding the possible introduction in due course by regulation of a seismic impact limit. The interaction between the introduction of a SIL and mitigation is explained below. The MOD's position, reading short, which has been discussed with the working group, is that a suspensive condition will not be appropriate where technical mitigation is required to meet a SIL, given that to confirm the suitability of and to validate and approve technical mitigation to reduce seismic impact would entail a further research project. The MOD would stress that the suggestion of a SIL is still the subject of research and discussion. It is not suggesting that the present application should be measured against a policy which is still to be considered and scientific research which is still to be completed. But as explained, it is relevant by way of response to the appellant's misleading comments regarding the sector deal. The MOD's objection to the use of suspensive condition in respect to the present development proposal has been consistent and is well founded. Now, I draw that passage, with apologies for looking at it in some detail, simply to place the MOD's position in its proper context. And this chimes with the present application in that we're in exactly the same territory unless and until that work has been carried out. The MOD will not be in a position to answer the binary question, yes or no, as to whether or not its objection remains or does not. It is anticipated from discussions at the working group that as and when a SIL is introduced, with all the background research which is required in relation to that, it is anticipated that the ministers may, I say anticipated, it may be that the ministers will ensure or seek compliance with the SIL through regulation, through secondary legislation. It may be that in addition or separately, without regulation, a SIL will operate under legal agreements and or under planning conditions or indeed Section 36 consent conditions. That is the context for the MOD's position in Little Hartfell about its, in principle, non-objection to the use of suspensive conditions, and it remains as at today's date and in this application. Turning more specifically, if I may, to the proposed condition, I noted Mr. Trinick yesterday saying in the discussion in the policy session that, and indeed with respect he's correct to have said this, that your recommendations and indeed the decision making in this application has to be as at the present date and not telescoping forward to imagine what might happen in the future date. And of course, if we answer the binary question, does the MOD object today? The answer is yes, it does object. And we know why it objects, because there is no headroom. It is suggested that at some point in the future, the MOD will answer that question in the applicant's favour. If one transposes that into the territory of conditions and validity of conditions, and if one looks at the proposed condition here, in reality, in substance, in effect, what this condition proposes is, and it's framed in the negative way, although I would submit in effect it's probably positive, because in effect there will be the applicant cannot proceed unless and until it gets a positive response from the MOD. That, of course, is something which is not within the applicant's wherewithal or control. That is why in the hearing statement at 5.2, the applicant submits, before we even get on to address the planning circular tests, although arguably the submission made in paragraph 5.2 that the condition is incompetent, address the first three tests in the circular, namely necessity, relevance to planning, and relevance to the development permitted. It is submitted on behalf of the MOD that the proposed condition is incompetent. It does not enable a final determination of the application, and it cannot be discharged, if at all, unless and until the MOD removes its objection. And as I alluded to earlier under reference to the Grampian case, the applicant accepts that it cannot resolve the adverse impact on the array because the headroom has been exhausted. And it does not propose any means to do so. It is not a conventional suspensive condition. It does not remove the traffic hazard. It does not mitigate the otherwise unacceptable impact on landscape or on habitats or indeed on radar operation. What it proposes is that the MOD may remove its objection. And if one asks what it is that the applicant has to do to remove the adverse impact on the array, it doesn't have to do anything. It simply sits back and waits for the MOD to consider all the material, all the work, and then come to a view. But it doesn't even propose what the MOD is supposed to do in relation to its consideration of removing its objection. As Mr. Trinick says, it's simply a binary question, yes or no. So for those reasons, and perhaps, as I say, shoehorning them into the first 3 tests of the circular, but I think probably the preferable analysis is competency rather than shoehorning into the first 3 tests of the circular. For those reasons, the condition is incompetent, in the language of the circular, unnecessary and irrelevant. If one comes on then to address the remaining 3 tests of the circular, enforceability, precision and reasonableness, those are addressed, albeit not in precise terms, not least because it's difficult, again, to fit them in, those 3 tests, into the very unusual terms of this proposed condition, but they are addressed in section 5.6 and following of the MOD's submission. And a lot of this material has already been looked at, addresses the proposed new approach, and we've already made the point that that new approach will not alone make headroom available. But I also invite you, ma'am, to note the statement that there is a large development ahead of the applicant in the list, that is Scoop Hill, which exhausts any available headroom. But if Scoop Hill is to be refused, it is not known if that itself would make sufficient headroom available to enable further development to be consented. And this inquiry is aware of other developments ahead of Greystone now in the queue, but is also aware that the MOD is going through this baseline audit to look to see what the current baseline properly is. And this is referred to at 5.6.2 of the statement. And you heard from Mr. Milne earlier today that it's anticipated that that will be available in about the mid-part of this year. And this is really addressing what may be required on the part of the MOD before it can answer the binary question, none of which is subject to the proposed condition. 5.6.3 talks about perhaps developing a revised algorithm, and that's referred to, I think, in some of the work packages as well. And then the obvious point, 5.6.5, and I think the inquiry appreciates this, and I don't think it's a matter of dispute between parties, that the threshold and whether or not it's been exceeded involves complex scientific calculations, assessment of this and all other developments consented and built, as well as pending and future developments. That all, with respect, seems to me, on behalf of the MOD, to indicate that there is a lack of precision involved here. It is not simply a matter of yes or no. The proposed condition by the applicant appears deceptively simple, but in reality it's anything but. It has no doubt been drafted so that, to answer Mr. Trinnick's rhetorical question, there is no prejudice to the MOD, because nothing will happen unless and until the MOD removes its objection. But if one frames it in that way, one can immediately see, in my submission at least, that that does not meet the tests which are required to be met for a valid suspensive condition. It may be, and to this extent I probably do agree with Mr. Trinick, that in looking to the test and the and many of my comments thus far also are relevant to the reasonableness or otherwise of the condition. But there is also the question of enforceability as well. And that is picked up in 5.10 of the hearing statement on behalf of the MOD. And a number of rhetorical questions are posed in that paragraph. How would it work in practice to discharge? Are we to await completion of the audit baseline? Are we to await any new predictive algorithm? Are we to await refusal of applications ahead of the applicants? Would the developer at some later point propose technical mitigation? Again, that suggests, with respect, that leaving aside enforceability, there again is a lack of precision here. And as we submit in the penultimate sentence in 5.10, the condition is the very definition of uncertainty. Contrary to what may, at first blush, seem to be elegant simplicity, I would respectfully suggest it's not simplicity, rather the applicant has adopted a simplistic approach. It is, of course, accepted that the decision maker, and I now note that apparently it's proposed that the condition be appended to the Section 36. So ultimately before the ministers following consultation, and of course it's accepted that the ministers would act responsibly. But again, there is this point made in 5.13 to the effect that, while of course the ministers will act responsibly, and there's absolutely no reason to doubt that they would not reject the MOD's objection, would not object the MOD's view that headroom would be exceeded. Nonetheless, there is the legal point posited in 5.13 that responsibility for the protection of the array is that of the MOD. It is not for the ministers, albeit with the views of the MOD, it's not for the ministers to make a decision relative to whether the headroom would be exceeded or not. Because, of course, they have no competence, legal competence, in the context of the devolution settlement to this international defence asset. And as a matter of law, and it's a technical matter of law, I accept that, but nonetheless an important one, we set out in 5.14 that this suspensive condition puts the decision in the hands of the consenting authority, albeit it does not have the devolved competence to make any decision relative to the array. As I say, if one wants to try and fit that into the planning circular test, that probably fits into the overall reasonableness part of the test. Mr. Trinick, of course, is correct to say that the MOD did not go through bullet by bullet the 6 tests in the planning circular, but as indicated at the outset of this morning's discussion, that is because it is very difficult to do so, having regard to the particularly unusual nature of this suspensive condition. It may be that the last point I've made relative to legal competence also is a matter of competence which was flagged up in the opening paragraphs of Section 5 relative to the removal of the objection. It's perhaps the other side of the coin, in which case one could also fit it into the necessity and relevancy parts of the circular. So for all those reasons, underlining again the particularly unusual, unconventional nature of this condition, it is submitted that UMAM should not recommend, if you're otherwise minded to recommend consent to this application, we should not recommend that consent be granted subject to this suspensive condition. And the MOD maintains its objection to the suspensive condition because it is incompetent for the number of reasons, a number of ways in which you could look at competency, and in any event would not meet what we commonly conventionally understand as being the test for a valid suspensive condition. Obviously, I'm happy to develop any of those points I've made thus far.
Thank you very much, Ms. Crawford. I'm going to go back to Mr. Trinick to see if he has any comments before I ask some further questions myself. Mr. Trinick.
Thank you, ma'am. Looking at the tests in Circular 4 of 1998, I'm not quite sure how the MOD comes to its conclusions. The question to be asked in relation to the necessity is, would consent have to be refused without the imposition of such a condition? Is clearly yes. Is the condition relevant to planning? I really hope we don't have an argument about that. Relevant to the proposed development? Clearly, yes, it's relevant to Greystone now. That's the way there's some locatory way developed by Ms. Crawford. Is the condition enforceable? Well, of course it is. It asks a binary question. If the answer is no, the development cannot proceed. And if you proceed in defiance of the answer no, it's impossible. Is the wording of the condition precise? Because precision relates to the wording of the condition. I've heard no arguments to say that the wording of the condition is imprecise. Most of the arguments here do revolve around the question of reasonableness. I add the following further points. That in terms of whether the condition is competent, that may be moving on to the next item on the agenda there, I'm not quite sure. But in the groundbreaking case, the event which was to happen before development could proceed related to some action taken to resolve a traffic issue. That action was beyond the applicant's ability to control. That event might never have happened. And yet the condition was perfectly competent. There's nothing different here. As to paragraphs 513 and 514, of the Ministry of Defence's hearing statement, there's no question of forfeiting the safeguarding of the array to another entity. The condition is written in terms that it is for the MOD to tell the ministers whether or not the condition may be discharged. And we can assume the ministers will behave responsibly and reasonably, so that if the MOD says no, then the condition and the development may not proceed. The MOD cannot be the planning decision-making authority for the purposes of a condition. It has got to be the Scottish Ministers or Scottish Borders Council to approve matters under a condition. That is the way it has to be phrased. There's no forfeit of safeguarding here. The condition is written in such a way as to preserve the MOD's safeguarding of the array, its ability to safeguard the array. And it envisages the same question being asked that has been asked since 2005, every time a development has come forward. Is there headroom for this development? Answer yes or answer no. There's no difference in that. It's the answer. It's a question the MOD has been answering since 2005. I await your question, ma'am.
Thank you, Mr. Trinick. If you'd just give me a moment to go back over my notes. The first question I have relates to circular, and it is for both parties. And I wanted to take you to paragraph 38 of the circular and negative conditions. So, my question to both parties is, could the proposed condition as set out by the applicant be considered as an example of a negative condition in the context of the circular?
Ma'am, thank you. And again, this is probably something I obliquely referred to in my earlier comments. I would also invite you, ma'am, to look at paragraph 37. The text is introduced in paragraph 37 about it being unreasonable to impose a condition in a positive form which developers would be unable to comply with, etc., or only with the consent or authorisation of the third party. And that's the context in which we now have negative conditions as figured in paragraph 38. But the next sentence of paragraph 37 is of some moment for the consideration of this proposed condition, where it is said, similarly, conditions which require the applicant to obtain an authorisation from another body, such as the Scottish Environment Protection Agency, should not be imposed. Now, before we get on to whether this is properly, it is for those reasons I would submit that this isn't a properly understood negative condition. In effect, in substance, and as I've already made the point, I think, perhaps in different ways, in effect, in substance, as Mr. Trinick says, a binary question has to be answered here, and that is, does the MOD consent? Or withdraw its objection might be a better way of putting it. The applicant has to get that positive response from the MOD before it can proceed with its development. So I would submit condition seems deceptively simple in its wording, but in effect, in substance, it is a positive condition because it requires the MOD to say yes.
Right. Thank you, Ms. Crawford. Mr. Trinick?
I obviously disagree. Looking at paragraph 37, that addresses the imposition of positive conditions which developers would be unable to comply with themselves, or which they can comply with only with the consent or authorization of a third party. And I think the words similarly build on the first sentence, conditions which require the applicant, positively, I insert that word myself, to obtain an authorization from another body should not be imposed. Then we have the contrast to paragraph 38, although it would be ultra vires to require works which the developer has no powers to carry out, or which would need the consent or authorization of a third party. Note those words referring back to paragraph 37. It may be possible to achieve a similar result by a condition worded in a negative form. So this is not a positive condition. The condition is worded in a negative form, as recommended in paragraph 38. I think that's answered your question. It's a negative condition. It requires that something should not happen until something else happens.
Yes, and looking at the condition set out on page 6, it begins with no turbine shall be erected until and in sequence. But then part 2 does require authorizations from another body, contrary to what is set out at paragraph 37. So the combination of the two, does, in your view, does that still result in a negative condition, or is it neither?
No, the key governing words are no turbine shall be erected until and in sequence two things happen. The first we've been through, and the second is, you can read it, no turbine should be erected until the Scottish ministers confirm in writing, etc., etc. That's a perfectly good negative, perfectly good suspensive condition. I don't see much argument there, I have to say. It is worded negatively. And I do draw that contrast again between paragraph 37, which says what you shouldn't do, and paragraph 38, which says, but you can do it in a negative form.
Okay, thank you, Mr. Trinick. Ms. Crawford, any follow comments to Mr. Trinick's response?
Well, obviously I don't accept Mr. Trinick's construction of the proposed condition, and you have my submissions on that. I did note with interest your observation, or rather asking, was it positive, negative, or something else? I would maintain my submission that it is, in substance, in effect, properly construed positive. But it may be that it's something else, or to use the Latin, and apologies to those who might be watching this, it may be sui generis, in which case, again, that points to the very unusual nature of this condition.
Right, thank you. Again, just a moment for my notes. I noted paragraph 5.10 of the hearing statement of Douglas Mill for the MOD that a number of quite specific questions are posed. I fully have the answer. Remind us that I do have the answers to them from both parties. These my questions all relate, and the questions set out in paragraph 10 all relate to the mechanism for discharge of the proposed suspended condition. I'm not going to go beyond the questions set out in paragraph 5.10, but I think probably the first one I would like to respond to completion of the MOD's audit of the base. Heard already today that is expected mid-2025. If I could go to Mr. Tree.
Ma'am, if I may, I'll answer all the questions in 510 quite quickly.
Thank you.
Will the applicant await the completion of the MOD's audit of the baseline? Yes. Will the applicant await a new Eskdalemuir seismic ground vibration predictive algorithm which removes or reduces the current 2014 element of a prediction? Yes. Will the applicant await the refusal of applications which are ahead of it in the consenting process, chronologically in terms of data validation? Yes. Will the applicant then ask, as those decisions are taken and as the safeguarding approach, technical issues underpinning policy and the Scottish Minister's guidance all evolve, whether the threshold will be exceeded? That's the condition. Yes. Would the developer at some later point in time propose technical mitigation? I think the answer has to be no, as at present advised on the basis of the technical work which has been undertaken. We don't think so at this distance from the array. So those are the answers to the questions. They're very simple.
Right. Thank you. I'm wondering, and perhaps, Ms. Crawford, you could clarify, is it the mechanism for carrying out these actions that you are questioning rather than the actions themselves?
It's not the actions themselves, but again, if you, ma'am, were minded to recommend this condition, and noting the answers which Mr. Trinick has given on behalf of the applicant, when it comes to enforceability and looking to precision relative to enforceability, if all things otherwise being equal and the condition did have its attractions to you, ma'am, we would respectfully suggest that the condition be amended to make clear what the applicant's position is in relation to these matters of mechanics.
So should a suspensive condition in the round terms proposed by the applicant be opposed on the Section 36 consent, should that be granted, you consider that an additional part should be added to any such condition, setting out the mechanism by which the applicant
Indeed.
Could satisfy those questions?
Indeed.
Okay. Right. I'm quite sure you probably don't. Do you have any suggested wording for that you can supply?
Well, not of, I would hesitate to draft on my feet.
I wouldn't ask you to do that either, Ms. Bond, just in case you had.
No. I mean, with respect, I would suggest it's really for the applicant. These questions were posed. There have been some revisions to the condition. Some more so. The initial iteration of it was far removed from what we have today. But with respect, it may be for the applicant to produce some suggested wording.
Mr. Trinick. We can do so. I don't think it's necessary to do so. The way the condition is phrased, part 2 of the condition, the MOD comes in writing that there is headroom. The The MOD will answer that question by reference to the approach which, following the consultation, it will adopt its safeguarding approach. It will adopt its first come, first served at the date of the application approach. That means that leapfrog another development and gain a better position in the queue. If the MOD decides, as part of its answer to the question on condition 6, we need mitigation, it would doubtless say no unless you provide that mitigation. I'm not sure the condition needs to be complicated in any way at all. I think the wording is sufficient as it is. But if you ask me to draft up something to look at, which covers these points, of course we will do so.
Thank you both. Again, a moment for me to consult my notes. I was going to take the MOD back to paragraph 5.6.1 of the hearing statement. And you spoke earlier, Ms. Crawford, about that are currently in place hill, which may exhaust any available headroom. It's also possible, isn't it, that those projects might not exhaust available headroom until the baseline is established later this year. That's an unknown. So that's the way we should approach it. Is that baseline, and until the middle of this year, there is no known. Correct.
And we agree with that position totally. I would add that a circumstance could arise, and I'm not saying it will arise, line will be completed, we don't know what's going to happen, but in terms of could this condition be purified within the life of a consent, that where projects ahead of Greystone now in the informal list at present maintained, all to be finally refused, including the exhaustion of any judicial review procedures. It might be that headroom could become available that way. I don't say would, I said might be. That is a circumstance which you might want to have regard to, noting that not only Scoop Hill, but Callister Hall and Little Hart Fell are recalled in that appeal at the moment. I go no further before the MOD gets too worried about what I'm saying and say it might become available.
Understood, Ms. Crawford. Would you like to comment?
I'll make a facetious comment. We have known unknowns, but now we've got unknown unknowns.
Oh, how cruel.
Right. Thank you very much. I'm content that I now understand your respective positions in relation to the actual proposed suspensive condition, and subject to any final comments I wish to make, I'm going to move on to the next item on the agenda. The agenda was, would the imposition of a suspension condition as proposed by the applicant be tantamount to assist in this instance? Would the practical effect of imposing such a condition on the Section 36 consent actually result in assist? I'm having microphone issues again. I apologise.
Thank you, ma'am. I've seen the argument in the MOD's case. My answer is this, that assist is a term to be used when an application for consent is suspended for some reason, a determination is suspended for some reason. And therefore, I think from the very start, it's completely inappropriate to use that term in the context of a development which has been decided, which has been permitted. You can't assist something beyond the determination. And the tantamount is just a rather loose word, although quite a good soundbite. The suspensive conditions have been used to cover many eventualities. If the MOD is to maintain its position that what is proposed here is tantamount to assist, I think it has to explain why it regularly acquiesces in the imposition of suspensive conditions to prevent implementation until a radar condition, shall we say, has been purified. It cannot claim, and applicants know this, that in such cases purification within the lifetime of a consent is predictable. We don't know. There are aviation conditions imposed on numbers of consents which are preventing their implementation. They may contribute to those list of unimplemented consents brought to our attention by Mr. Kelly and Professor Hughes. We don't know when those sorts of conditions are imposed, whether or not they can be purified. Also, address here the MOD's contention in its hearing statement at 5.4 submitted that the grant consent for the proposed development subject to a suspensive condition that depends on sufficient headroom being available without any proposal having been made to mitigate the admitted adverse impact of the proposed development on the detection abilities of the array is an attempt to circumvent the requirements of the EIA directive. It comes down, it's the same, it's related to the SIST point. That's quite imaginative. Impacts on the array are not a required topic for EIA in the first place, under the regulations. And I refer again to the Grampian case, which, as here, dealt with the imposition of a condition to cover an event over which the applicant had no control. The applicant in the Grampian case had no idea whether that condition could be discharged within the lifetime of the consent at the time it was imposed. And yet there's no contention in the Grampian case that that was tantamount to assist. There's no difference between the Grampian case and here. So that's my answer.
Thank you, Mr. Trinick. Ms. Crawford.
Thank you, Ma'am. I think you anticipate perhaps the views of the MOD that, and indeed as they set out in their hearing statement, it is in substance and effect a SIST, and the reasons for that in distinction to, for example, aviation mitigation, which is like comparing apples and pears. In substance and effect, it amounts to assist because, and I may sound like the broken record here, it cannot be discharged until such time, if at all, the MOD removes its objection. And it's not proposing mitigation, unlike the question of aviation controls or radar controls. While I refresh my memory of the relevant EIA regulations, oh, Mr. Mill's done it for me. Yeah. 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 I'm reminded of Schedule 4 of the Electricity Works regulations, and paragraph 4 requires the developer to describe various factors likely to be significantly affected, including material assets. And I would submit that the array is a material asset. And I'm reminded by Mr. Milne that the array is one of the assets which is assessed, albeit we would say with a very, very light touch indeed, in the, its environmental report. And that also links in, if I may say, to some of the observations made yesterday relative to NPF 4, Policy 11E4, where the applicant requires to demonstrate how the development by design, etc., has mitigated adverse impacts on seismological recording, i.e. the array. And the MOD would submit that it has neither complied with the relevant regulations nor Policy 11E4, Roman 4, because its assessment of these matters is not to propose mitigation. It's not to avoid, minimise, offset, etc. Its addressing of these matters is simply to say it's for the MOD to withdraw its objection.
Thank you, Ms. Crawford. Mr. Trinick, would you like to respond? Ms. Crawford, I'll just get you to switch your microphone.
Absolutely.
Thank you, ma'am. We disagree in relation to the regulations. The regulation, I think it's 4 from memory. Not so much that the schedule tells you if EIA is required, what you have to look at, but the 4 topics listed in the regulation itself require EIR to describe and assess direct and indirect effects of the development on population and human health, biodiversity, land, soil, water and climate, and material assets, cultural heritage and the landscape. Now, we take the view that material assets do not here include the topics such as Eskdalemuir. I don't think it really matters in the end, because actually it has been addressed in the EIR anyway, so you may be absolved from making a difficult decision there. But that's the point I make. In terms of the policy 11E4, since it's being covered, first of all, this is not a matter of project design, which is referred to. It's purely a matter of location at 45 kilometres from the array. That's where the development is. We can't alter its distance. Were it to be in the seismic impact limit zone, the SIL zone, turbine choice and layout could be an issue because of the possible need to provide mitigation. But mitigation, and I haven't heard this counted yet, is not an issue for a project at this distance from the array, because it's not within the zone where the seismic impact limit would apply. That's much closer to the array itself. Second, there's no requirement to produce mitigation for Eskdalemuir. The MOD knows perfectly well that the MOD, quite rightly, would not currently accept technical mitigation. And there is no approved technical mitigation. We're not going to be silly enough to promote mitigation. It's going to be refused. And we would agree with the refusal of such mitigation in this case, until and if the work packages are complete and some form of mitigation is approved by the MOD. And we're well away from that. Instead, as it's perfectly entitled to do, we have proposed a safeguarding condition which works. Thank you, ma'am.
Thank you, Mr. Trinick. Just back to the MOD for some clarification for me on the issue of mitigation within the different zones for Eskdalemuir. In your opinion, is that correct, that mitigation is not necessarily required or applicable at the distance that Greystone now is from the array itself?
Ma'am, that's another who knows response, because we don't know what headroom is available. It is correct to say that work is ongoing trying to work out the seismic impact limit, but whether in fact that comes to what results from that is dependent inter alia on what headroom is available. But as a broad, very broad crude, and Dr. Bowers may be tearing his hair up behind me, it's a very broad rule of thumb. The further away from the array you are, the less seismic ground vibration is emitted at the array.
That's my understanding from the papers already submitted, but in answering that it's another unknown, is that again dependent on the work packages being carried out in relation to the SIL and also to the audit of the current baseline?
Absolutely.
Okay, thank you very much, Ms Crawford. Mr Trinick, I think you were coming back.
I'm hesitant. I'll push the MOD a bit on that I would suggest that enough work has been carried out for Dr. Bowers to be able to confirm that at a distance of 45.2 kilometres from the array, it is so stunningly unlikely that mitigation might be. If there is headroom, then there's headroom at that distance. Mitigation is not an issue.
Indeed, rather than me filtering through his understanding, if I could invite Dr. Bowers to address you, ma'am.
Thank you, that would be useful.
Oh, thank you, ma'am. So,
just before you start, Dr. Bowers, could I ask you to just briefly introduce yourself and your position, just for the benefit of those in the room and those watching on the webcast?
Absolutely. So, I work for a company called AWE, and we're contracted to the Ministry of Defence to provide advice on seismological issues, one of which is the part of safeguarding. I've been working on this since 2003. So it is correct that the value of the ground vibration predicted from wind turbines at the outer reaches of the consultation zone is a small value. That's correct. But of course, when the audit is complete and different models are considered, the headroom that's of course be less value, in which case some kind of mitigation would be required. I accept that it is unlikely, but I guess the experience over those 20 years is that quite often the very unlikely can turn out to be the case with the order of things. So it's possible.
Thank you, Dr. Bowers. So then fair to say that there could be a cumulative impact in terms of other turbine developments in the outer zone, which will give rise to a need for mitigation.
So there are kind of two situations which depend on where we are now, so there is the MOD's proposed policy, which has been consulted on. So if that is where we go forward, then first come, first served, and how the list is ordered could indeed mean that developments ahead of Greystone Knowe in that list would result in a situation where the headroom was less than the amount needed for Greystone Knowe to go ahead without mitigation. If in the future a different approach, along with Scottish Government and others, were to be adopted, and that's dependent on the work that these work packages and then subsequent questions and policy and guidance coming in force, which would, under the current proposals, involve this seismic impact limit, then depending on when in time that was imposed, the sill is unlikely to affect Greystone though.
Thank you very much, Dr. Bowers. I am clearer after your explanation. Thank you. Mr. Trinick.
I would dare argue with Dr. Bowers about anything at all, so I'm not going to. What I would say is that I think I hear him say that it's unlikely but not impossible that mitigation might be required for Greystone now. I think it's a fair summary. If we don't know, therefore, at the moment, whether or not mitigation might be required in that scenario, it's still covered by the condition. Because if we ask the question, is the headroom, the MOD's response could be yes, it could be no. Maybe it's not entirely binary. It could be yes if mitigation is provided, which we approve. That scenario is also covered under the condition as drafted. Or no unless you do something, yes if you do something. That's both perfectly valid replies under the question posed and the condition.
I'm going back to part 2 of the proposed condition, and looking at the first sentence, second line, the seismic ground vibration of the wind turbines within the development shall not cause seismic ground vibration of wind turbines within 50 kilometres of the array to exceed 0.336 nanometres. Does that provide for mitigation, or is that an absolute condition?
If we propose to the Scottish ministers that the development proceed without breaching 0.336 nanometre ceiling, the MOD, when consulted, could say, if no mitigation is required and there is headroom, yes, it can proceed. If it is quite clear that whatever is done, it cannot proceed, however much mitigation is applied, the answer is no. But the answer could also be, yes, it could proceed if mitigation is proposed and approved. There's nothing wrong with that. After all, under an aviation suspensive condition, the mitigation which is secured by condition is not totally defined at that stage. Mitigation may not actually be known. But a condition is imposed that mitigation package shall be developed, approved, and then implemented. There's no difference to the aviation condition in that respect.
I take your point, but without thinking of a specific example, but generally aviation conditions identify that mitigation is required. The actual mitigation isn't necessarily itself identified. Whereas part 2 of your proposed condition does not address any potential for mitigation. But are you saying that it's inherently available in terms of exceeding 0.336 nanometres with or without mitigation?
Yes, I am. And actually, I go further. This condition could be imposed perfectly happily, in my view, within the sill zone where you know you need mitigation. In the same way. But I do come back to that parallel of aviation conditions. At the time such conditions are imposed, that is a known unknown, so we'll run that phrase again, for the developer. The developer does not know that condition can be purified. We don't know at that stage.
Ms Crawford, would you like to respond?
Thank you, ma'am. It's really, again, to emphasise that the MOD's point, which I understand that the applicant has accepted, is that any form of technical mitigation, the MOD's view is that that's not appropriate for use in a suspensive condition, because inherently that would involve a research project, which does not be appropriate form the basis of an application to discharge such a condition. As regards the parallels with radar mitigation, air defence or military air traffic control, radar, ma'am, you're obviously familiar with the format of conditions where there is at least an express reference to the requirement for mitigation. It may also be helpful to know the MOD's long-established position in relation to mitigation for military radar is that before the MOD would confirm to a consenting authority that it is able to withdraw its objections subject to the imposition of a suspensive condition, the MOD would require mitigation to be proposed to it and for that mitigation to undergo an operational and a technical assessment. None of that has happened here. The MOD would be quite concerned at any suggestion that the condition which has been proposed would open up the possibility of technical mitigation in respect of the Eskdalemuir Array.
Thank you, Mr Milne. I'm content that I understand your positions, but I see Mr Trinick would like to make a further comment, which I'm happy to
Just
hear.
one more comment. That the comment from Mr Milne about a research package, yes, at the moment, as of today's date, the requirement for technical mitigation would involve a research project. This consent lasts 5 years. That technical mitigation might well be approvable within the lifetime of the consent. It might not be, but it might. And that's the point I make. It's not simply, we're not simply looking at today's date, we're looking at the next 5 years. That's my only comment, ma'am.
Thank you both. I'm content to move on to the next point on the agenda. We have covered briefly some of these matters, but I think they're worth revisiting specifically for my benefit. Mr. Trinick, the bullet point said, is there any certainty, but I do take your point, reasonable prospect of such a condition as proposed by the applicant, that it could be discharged within the 5-year implementation period sought in this application?
2 points. First of all, we don't believe that the reasonable prospects test should be applied, but you've got my submissions on that. If it is to be applied, our belief, and it's not hard evidence, it's a belief based on the contract for the work packages, based on the commitment by the MOD to do its level best to try and see this succeed, based on the fact of the MOD's consultation on its own safeguarding approach. I know that was undertaken for other reasons because of the undertaking to the court. Nevertheless, that's taken place. And based on the commitment by the Scottish Government in the sector deal to try and see this thing through and release capacity within the zone, based on those factors, I think there's at least a baseline of evidence that there are reasonable prospects that the condition could be discharged. I'm not going to go further than that. I'm not going to try and give hard evidence on that. But there are reasonable prospects, in my view. It's a subjective judgment.
Thank you, Mr. Trinick. Ms. Crawford.
Thank you, ma'am. So far as reasonable prospects is concerned, as the MOD makes clear in its statement at 5.8, it's accepted that such a test does not apply as a matter of law. But it doesn't mean that it is not open to a decision maker never to apply such a test, and examples are then given relative to that, including Minister's guidance on aviation objections. And it is submitted, of course, that UMAM should consider a reasonable prospects test to be appropriate in this case. In a direct answer to the question, can such a condition be discharged within the 5-year implementation, using that through the lens of reasonable prospects rather than certainty? Of course, that is not known. I did earlier point to the Little Hartfell submission made by the MOD, and the reference there to the statement indicating that the Scottish Government would produce a consultation document in January 2024. Well, here we are in January 2025. I have no doubt whatsoever that the Scottish Government has a very, well, we know its ambitious renewable energy targets, and we know its desire to maximise renewable energy within the consultation zone. But with respect to the Scottish Government, because I suspect the work is so complex, so difficult with a number of interchanging parts, not much has happened. And that's really all I can say, recognising goodwill on all sides and a desire to sort matters out. But we haven't moved that much further forward in the last 2 or 3 years.
Okay, thank you. I note both of your positions and I'm content with your answers. The next bullet point I had put on the agenda was the appropriate consenting authority, and adding to that relating to the authority for enforcement. Should consent be granted subject to the condition proposed by the applicant? We have actually touched on this earlier, but if I could have some specific answers, that would be useful, starting with Mr. Trinick.
Thank you, ma'am. I've already said I think it's appropriate to impose the condition on the Section 36 consent. Clearly, enforcement powers are available to compel compliance with that condition. It could be imposed on the Planning Permission, in which case enforcement powers are available under the Planning Permission. As for the MOD's case that the Scottish ministers are not the approving body under conditions, should not be the approving body under condition 6, I'm afraid that planning law means that only they can be the approving body under that condition. Or if it's a planning condition, Scottish Borders Council. I've already dealt with the question of forfeiting decision-making to the Scottish ministers. No such thing. I've already said that the MOD has the right to say no, and we, sitting here, must assume that the Scottish ministers, behaving reasonably, would accept the answer no and decline to purify the condition. I'm not sure I can say any more. I think it's already been rehearsed to a degree.
Thank you, Mr. Trinick. Ms. Crawford.
Ma'am, thank you. If you were minded to recommend condition 6, the MOD would consider it more appropriate that the Scottish ministers be the authority which requires to look at whether or not the condition has been purified for any number of obvious reasons, which is probably unnecessary to articulate. But I would pause to observe that not every renewable energy development, of course, is a Section 36 consent, and some will proceed, if they're below the 50 gigawatt level, will proceed to be consented by the local planning authority. And I make that point with all proper and due respect to planning authorities across Scotland, or at least within the consultation zone, because it may be that they will require to task themselves with similar conditions in the future, and we know how stretched resources are at local planning authority level, and I do have a slight concern there insofar as precedents are concerned.
Thanks, Ms. Crawford. Is it?
May I just make one more point?
Yes.
I forgot about that. Quite apart from enforcement, under the terms of Section 36 itself, a breach of a condition would be an offence. You'd be carrying out a consent other than in accordance with the terms of that consent. Under section 36(6), that would be an offence.
My question is for the, well, it's not a question, it's an observation. So in terms of should any condition similar to condition 6 as proposed be imposed, it should be imposed on the section 36 consent rather than the planning permission. Yes.
That would certainly be the MOD's preference. Least worst option.
Thank you both. Again, we have actually touched on this matter, moving to the next bullet point on the agenda, and I intended to explore the potential impact on and of other proposed developments in the consultation zone. For example, I put proposed Scoop Hill wind farm on, but I note that Woolmuir is right on the boundary. It's just received consent. It's a PP rather than a section 36. It's on the actual Eskdalemuir consultation zone line as mapped by Anderson in KA1. What I wanted to explore in that bullet point, but we have touched on it and you may feel that you don't have much to add, is if Greystone now received consent and a condition similar or as set out, 6 was added to that consent, is there a potential impact on other projects within the zone, be they planning permissions or section 36 consents?
Before I address that question directly, and I suspect again the answer will be somewhat vague, but just picking up the last application which has now been consented, the PP has been granted, which has been mapped as being just on the border of the consultation zone. For the avoidance of doubt, the MOD was not consulted about that application. Therefore, it didn't put in a response, and therefore it didn't object. Although, if it did fall over into the consultation zone, it would have exceeded. There wouldn't have been headroom available for it.
I'm going to go on a reasonable assumption that, based on the scale of mapping, it's probably outside the red line then, if you weren't consulted on it. I don't know that, but I think that's a reasonable assumption for me to make. Okay.
Yeah, I'm told by those who maybe have looked at the mapping, micrositing may take it just within the consultation zone, which again is why much has been made by the MOD in relation to this application about the importance of micrositing, because it can have a noticeable effect. I was going to say significant, but I suppose it depends exactly what we're talking about, but it certainly could have an effect on the ground vibration and the calculations. Turning to the actual question, ma'am, the answer is, and I said it's going to be vague, the answer is potentially. And I don't think I can be any more certain than that. And I'm sorry to be unhelpful in relation to that.
No, that's absolutely fine. I anticipated that would be the case. Mr. Trinick, do you have any comments to make?
Very, very quickly, yes. Because I partly addressed this matter under agenda item 5 already. But dealing with Scoop Hill, the facts there are very different, of course. The applicant is advancing technical mitigation. I think it's also advancing a novel approach to safeguarding the array, shall we say, which we needn't discuss here. But a different approach entirely, not simply technical mitigation, but a different idea for safeguarding. If Greystone now were to be consented before Scoop Hill was determined, the list operated by the MOD and proposed to be operated in the future would stop Greystone now grabbing Scoop Hill's budget. So there'll be no prejudice to Scoop Hill if consented.
And is that based on the application date of the
Based
respective
on the
projects?
application date. I think that's fine. The other two, you listed Scoop Hill. There is, of course, also Callister Hall and Little Hart Fell, which are much closer to the array than Greystone now, both of them. Both are at appeal, both have been recalled. One was recalled in 2023, the other last year. Both have their positions in the MOD list. I don't know if they're ahead or behind of Greystone now, but the MOD may be able to tell us. But neither would be prejudiced if ahead for the same reasons I've given in relation to Scoop Hill. I think that's all I need to say in answer to your question.
Right. Thank you very much. I'm satisfied that I have what I need from that question. Are there any final comments on that part of the agenda before we move on? Ms Crawford.
Just if I might advise the inquiry that the developments which Mr Trinick mentioned are ahead of Greystone now.
Thank you very much, Ms Crawford. Apologies. Moving to item 4 on the agenda, any other relevant matters. I myself don't have any to add at this point, but I'm quite happy to hear anything else of relevance that either party or another party who's attending today may wish to raise at this point.
I have none, so ma'am, that was very thorough indeed and appreciated.
Thank you, Mr Trinick. Ms Crawford.
No, I have nothing which I could usefully add. Thank you.
Thank you very much. I know you have been the primary parties in this discussion this morning, but there are other attending parties. Before I conclude, can I confirm that none or any of you have any comment to make?
I don't think you can quite safely make that assumption. What I want to do is say to you that the public perception aspect of this problem hasn't had much of an airing today, and that's quite right, because the MOD's and the applicants' positions don't take that into account. But I will be referring to that aspect of the matter in my closing submissions to you.
Noted, Mr Campbell. Thank you. And Racial Farms Limited?
No, nothing further from us, ma'am.
Thank you, Ms Leslie. And Scottish Borders Council? No. Thank you very much. It then remains for me to close this hearing session, to thank you all for the considerable effort and time you've put into preparing the answers to my agenda questions and in helping me understand the respective positions of the parties. It is, as I said, much appreciated. The next action will be the noise inquiry session this afternoon. The inquiry sessions will then close, and I will move to preparing my report for submission to Scottish ministers. That is due on the 4th of June, but will be submitted on or before then. Thank you all for your participation this morning. I shall see some of you this afternoon. Thank you. Oh, now it is 12:22. Would it be possible to begin the inquiry session at 1:30? I think with Mr Williams and Professor Hugh to be available for 1:30. That's still the case. In which case, is that convenient for everybody?
Yes.
Excellent. Well, then I shall see you all back here at 1:30. Thank you again. session. It's an inquiry session into noise issues, and it's just after 1:30 on Thursday, the 30th of January 2025. I won't rehearse the introductions I have made to the various inquiry sessions this week. We'll move straight to introduction of the parties. If I could start with Mr.
Thank you, Madam. Marcus Trinick, Solicitor of King's Counsel, instructed by Amy Howard of Wright Johnson Mackenzie, sit to my right, and I'll be calling Dr. Matthew Cand as my only witness.
Thank you very much, Mr. Trinick and Mr. Campbell.
Thank you, ma'am. Good afternoon. I'm John Campbell. I appear with the Heriot Community Council, the Fountain Hall Action Group, and Mr. and Mrs. Walgate Farmers Corsup. In this inquiry session, I'm accompanied by Mr. John Williams, Chairman of the Community Council, who sits to my left, and my only witness is Professor Gordon Hughes, who's sitting to my right.
Thank you both. I won't, as I said, rehearse, but I do need to remind you of our protocol. Should you wish to see that in any more detail than I've already described, it can be found on our webpage. This afternoon will be, as it normally is for inquiry sessions, the witness will be introduced. Their evidence in chief will be given, drawn from their precognition and relevant inquiry statement or report. The witness can then be cross-examined by an opposing party if so wished. The reporter would then ask any questions of the witness, should she wish to do so, and then the witness can be asked some further questions by their own legal counsel, and that is referred to as re-examination. It's not obligatory. When all the topics on the matter in the concluded, we will draw proceedings to a close, and I would again remind parties to be courteous and kind to each other. Some small housekeeping matters. Again, there is no fire alarm proposed for this afternoon. Should a fire alarm go off, it is a real fire alarm. Please move to the emergency exits, which I think you have all heard me describe. One thing I did forget to remind people of this morning is please be aware of the electricity cords which are attached to various extensions across the room. Please be mindful when moving around to try and not trip over those. Are there any questions regarding the procedure? No? Well then, I will move to formally open the inquiry, and we will firstly hear from Dr. and Mr. Trinick, if you care to begin.
Thank you, ma'am. I call Dr. Cand. Before we start, there is an extra document which Mr. Campbell has indicated he's happy should come in, and I've got a hard copy for you, and it will be emailed to you. And it will be explained by Dr. Cand when we get there.
Okay. Just for the purposes of the recording. Sorry, my microphone is doing things. This is a table which is an assessment and baseline data at Wester Coursehope during daytime periods. Thank you all.
CD 1112.
11:12.
Yep.
Thanks.
Dr. Cand, you've submitted an inquiry report. Grateful to the reporter for agreeing you need not submit a recognition. It's quite a short report. We can take that as read. But I do have a number of points to put to you from the evidence of Professor Hughes. And we go first to paragraph 23 of his inquiry report, which is CD 15-6. And he says, 3 lines down, the figures in the table, this table 1019 of the environmental statement, show that Woolmere adds 0.2 dB to the cumulative noise at West Coursehope and 0.4 dB to cumulative noise at Coursehope Farm. I have this question for you. What is the acoustic significance of an increment of 0.2 to 0.4 dB due to Woolmere?
So in simple terms, this is a negligible increase. The reason I say this is because the way the ears perceive noise is well understood and studied, scientifically for many years. You could not discern a small change of noise of less than half a decibel. Like this, you would play 2 sounds that differ by this much. Your ear could not tell, could not distinguish that increase. You would also probably struggle to even measure it with a very sensitive equipment. It's within the uncertainties of measurements you would have. And that's the reason why in my inquiry report which is CD 11.6 at paragraph 3.4, I explained that in a document called the Institute of Acoustic Good Practice Guide. I quote a section from there that says, if another wind farm is 10 decibel below another one, we can consider that negligible. And that's because when you take a noise and add something that's 10 decibel below, there's a theoretical increase of less than half a decibel. And because that's not perceptible or discernible, it's considered negligible. You simply not notice it.
Thank you. If you go to paragraph 13 of Professor Hughes' inquiry report. And we're on the same topic of subjective perception of noise. He says in paragraph 13, an increase in the noise limit of 2 dB translates to an increase in noise exposure of nearly 60%. For future reference, an increase of 3 dB is almost exactly equivalent to a 2 times increase in noise exposure. Now, based on your knowledge not of statistics but of acoustics, what is the significance of an increase in decibel level of 3 dB? Does it really represent a doubling of noise exposure?
So that's not a good representation, no. Again, based on the way the human ear perceives noise, 3 decibel increase, we generally describe that as the smallest perceptible increase in noise. And what that means is you would perceive that as a marginal slight increase of noise. Even though the energy has doubled, it's a small increase in noise. And anything less than 3 decibel, you would struggle to notice this increase. That's just how the human ear perceives noise. So, yes, an increase of 2 decibel, you would play one noise side by side with a 2 decibel increase. You might struggle to notice which one is the loudest. Whereas to have a doubling of loudness, to have something that's perceived to be twice as loud, you would need a 10 decibel increase. That's the rule of thumb. So an order of magnitude more to be a doubling in perceived loudness.
And what is the knowledge that you've shown in my last 2 answers? What is that based on?
It's based on long experience and scientific studies of people's responses to noise, and psychoacoustics is called as a field. And you can verify, you can listen for yourself there's lots of websites where you could play back the difference in noise. You can say, what's a 3 decibel increase sound like? You can verify for yourself, but it's based on studies of human response to noise.
Thank you. One point from your report at 317, and dealing again with the cumulative effect of Woolmere and Greystone together, you observe the predicted contribution of Woolmere as not exceed 27 dB at the lower minimum fixed noise limits for Greystone now. If they were set to 37 dB daytime, 43 dB nighttime, this means in most cases Woolmere will be more than 10 dB below the proposed noise limits for Greystone now. And you've already dealt with that question of being 10 dB below the received noise level from the project being assessed. This therefore satisfies the IAEA GPG test set out above 3.4, and you've dealt with that. The sentence I want to explore now is, furthermore, as discussed in the previous section, this assessment is precautionary as it effectively assumes that the locations would be downwind of all turbines, that is, turbines at Woolmere and turbines at Greystone now, which would not be the case in practice. What do you mean by saying that that assessment, therefore, is precautionary, as the properties could not be downwind of both wind farms?
Yes, so we know, again, from the study of propagation of noise in general and wind farms in particular, the worst case conditions tend to occur. The main factor for the noise propagation, it tends to be the wind direction. And we consider that downwind conditions are the worst case. And by downwind, what I mean is the wind blows from the turbines towards the receptors, the neighbouring properties. And all the predictions are generally, in the various EARs are generally presented in terms of those worst case conditions. Well, so when we, in the Woolmere EAR assessment, when they took the noise from Woolmere and added it to the noise from Greystone Knowe to get this 0.4 or 0.2 decibel increase, that effectively assumes that you will be downwind of both wind farms at the same time. So, and I can take you to the cumulative map we were looking at this morning, which is reference KA1. I think we were looking at this.
KA1.
KA1.
If you don't have the landscape and visual map, the map we used this morning for Eskdalemuir will do just as well.
Yes, there was this map with the buffer, the 50
hold on,
kilometre buffer.
wait.
I did have one. I think I was quite tidy.
I've got a spare copy if you want one, but...
The original KA1?
Yes, absolutely, do just as well. We don't need the Eskdalemuir line, so that's fine. Hold, Mr. Dr. Cowan, just wait a moment. Okay, go.
So you've got this map, yes. So essentially we've got, you can see the Greystone Knowe wind turbines in the centre of the map. And the properties that are of concern in this case, where this issue of cumulative noise has been raised, are essentially to the northwest is Wester Corshope and Corshope Farm. They're about 1 kilometre to the west and northwest of the Greystone Knowe turbines. And you can see that for these properties, the Woolmere turbines are located to the north. So effectively, it's just not possible for the wind to blow from the Woolmere turbines to these receptors and at the same time blow it, because from Greystone Knowe to these receptors, because that's just not physically possible. They're located, diametrically opposed from the perspective of this receptor there. So essentially, this addition of noise, even 10 decibel below, adding up to a 0.2 to 0.4 decibel increase, is assuming this impossible wind that comes from both directions at the same time. In reality, when one side is upwind, it would tend to be much lower, like at least 10 decibel below that. So the real increase you would get is much less than 0.2 to 0.4. It might be close to zero, really. It's a really precautionary assumption, really.
Just to complete that answer, when you say downwind,
Yes, there's a tolerance, there's a certain tolerance, a certain arc, but even accounting for this, we...
you're taking it beyond my question.
Right.
It's about 45 degrees sector.
It's about that, yes.
All right, sorry. Just to add to that answer, we've already taken the reporter through the implications, but I wanted to get the sector point across. We're going to explore wind shear. We're on paragraph 13 of CD 2.19, but I'm not going to the paragraph yet, so that was rude. I apologise. What do you mean by wind shear? What is understood by wind shear?
So it's a term that just denotes the change in wind speed with height. So broad terms, to simplify things, as you go higher and higher up, the winds get stronger. And that varies, according to lots of factors, but that's the basic phenomenon.
Right. Well, in paragraph 13 of his 2022 report, Professor Hughes has a critical simplification built into the noise assessment prepared by Hall Lee is that the ratio wind speed at hub height to wind speed at 10 metres above ground level is constant. This assumption is important because it implies that for each wind speed at 10 metres, there is a single level of noise output from one turbine or multiple turbines. Hence the exercise of comparing the level of background noise of multiple levels of turbine noise for each wind speed is reduced to a straightforward one-to-one comparison. All the analysis and the noise assessment rests on this key assumption. What's your response to that?
So in simple terms, we've not made an underestimate or an error. I think that's a misunderstanding from Professor Hughes. And I can explain why. To be fair, it is quite a confusing area because of this.
Well, keep it slow and keep it simple. Just explain it.
But in simple terms, what we have done is both the background noise, which is the baseline condition of noise at the properties, and the prediction of the turbine noise, which are proposed, they are both referenced to the hub height wind speeds. So these are the wind speeds to be experienced by the turbines. And that drives the whole assessment. And therefore it has been done on a like-for-like basis. So we're saying when the turbines will be producing a certain level of noise that we're predicting based on the tested emission data from the manufacturer. We've measured in similar conditions what the background noise is, and there's no discrepancy there. I think what perhaps introduced some confusion is that both the hub height wind speeds, so for the prediction and for the background, they've both been corrected to a notional 10-meter wind speeds, and that's for historical reasons. That's how the noise emission test for the turbines, when they are tested according to a test standard, which I'll put the reference. It's called IEC 61400-11. We mentioned that in our technical appendix, Annex F of our technical appendix 10.1 explained all this. But it's actually, for all intents and purposes, this is a hub height wind speed. We've used in both cases. So there is no need to apply a correction to account for the variability of the wind shear. because it's been taken into account, and we've followed the procedures which are established in the Good Practice Guide, which is CD 9.7, which provides a procedure to follow, and we've followed that procedure.
So, reverse this back, so that even this steward person understands what you're saying. That Professor Hughes would have a good point if you were comparing wind speeds at hub height with a baseline noise at 10 metres.
Yes.
Because then you would need to account for wind shear by a multiplication factor to take the V10 noise up to hub height.
Yes.
Then you would need to do it. And historically, as I understand it, I will lead you a bit here, but forgive me, but historically, when turbines were much smaller, wind speed was indeed measured at 10 metres height. As turbines got taller, so the discrepancy between 10 metres and hub height became greater and greater, and that is why there was introduced the method of measuring wind speeds, measuring turbine noise and background noise relative to wind speeds only at hub height, so you are comparing like with like.
Yes.
And that avoids the need for any wind shear corrections from V10 up to hub height.
Yes, we have a robust assessment. There's no need for further corrections.
Thank you very much. If you go to Professor Hughes' inquiry report at page 30, paragraph 38, he says for West Corsope and Corsope Farm, the use of turbine mode 9, we'll come on to mode 9 later, that's not the purpose of this particular question, reduces the frequency with which the proposed noise limit of 37 dB is exceeded. However, it does not alter the conclusion that for many periods, over 50% at West Corsope and over 25% at Corsope Farm, the noise threshold of 37 dBA will be exceeded. Now, this may be an example of the application of a wind shear correction, or it may not. But so far as you can understand, this is not being rude to Professor Hughes, what he says in that paragraph, what is your response?
So I think, as best as I can tell from reading both his reports, I think what's being done here is these 50%, 20% corrections of the time, they are based on adding these corrections to account for this discrepancy of wind shear.
It's a wind shear correction.
It's a wind shear correction is to account for this wind shear effect, which, in his view, we've not accounted for, but I'll explain why we did account it for. And that's why there is this additional probabilities, whereas, in my view, because we've accounted for it, our prediction of noise represent the worst case in downwind conditions, without the need to have further corrections.
We'll come back to low noise modes probably on the next question. It's best to deal with it there. Is that right? Yeah. The next question then is paragraph 39, the very next paragraph of the Professor Hughes' inquiry report. Overall, the implementation of a noise mitigation strategy involves the operation of turbines in low noise mode does not correct the basic problem with the Greystone Knowe proposal. The critical receptors, which are named, will in varying degrees still be exposed to an unacceptable increase in their levels of noise exposure. Can I ask first, what is your experience of variable speed turbines, and all modern turbines are variable speed, operating in a reduced noise mode operation? Not very well put, but you get what I mean.
Yes, so with modern turbine models, as you have now, Mr. Trinick explained, this is their variable speed, which means that they'll rotate slowly in low wind speeds, and then as the wind picks up, they'll rotate faster, simply what it means. And essentially all these turbine models on the market now do come with this possibility of operating in reduced noise mode operation. but you know, from my experience, not just from predictions, but also we've undertaken measurements of operational wind farms, and we've seen that these nodes do work as predicted, as measured, and they are effective in reducing the noise. Essentially, in simple terms, what they do is they reduce the rotational speed of the turbine. A bit more complicated than that, but essentially they do that. It's something like that. And that reduces the noise, reduces the power generation marginally, but they're still generating, but they're with reduced noise. So they are an effective way of controlling the noise. And so we're confident that the noise limit can be achieved with the parameters we've proposed as an example, with 4 turbines operating in...
Yes, stop there.
Yep.
Stop there. Because these are... In this case, how many of the turbines will need to be operated in a low noise mode for the purposes of Western.
So in the EAR, I can take it.
We'll give a figure and then we can check it back later if we have to.
It was set out anyway in our assessment that based on the turbine model assumed, operating 4 of the turbines in a reduced noise mode, or a combination of 2 reduced noise modes, in certain wind condition would be sufficient to achieve the proposed noise limit.
Now,
I'm sorry, I didn't catch the end of your answer.
sorry.
Can repeat. So we determined
Just the last few words. You said just something.
it would be effective to meet the derived noise limits.
Thank you.
So that, to be clear, the EIAR uses a candidate wind turbine. Doesn't matter which, don't worry, you don't need to go to it. But for that candidate turbine, a reduced operational mode for 4 of the turbines will achieve what is required in terms of the rating curve. Is that correct?
Yes.
And if we go to your noise report, and I mean not inquiry report, but to the CD17, which is the technical appendix to the EIAR, Appendix 10.1, and I'd love to give you a page number, but there isn't one. There's an Annex E, that's what you're looking for, Annex E. Which is on internal page 67, but I'm not sure it's going to help you.
Is there a paragraph number?
No, it's a figure, I'm afraid. It's a figure E7 when you get there. Thank you very much.
And helpfully on a hard copy.
It's right towards the back of the document.
Annex E, background noise and noise level.
That's the one. E7, which is the last figure in that series.
Yes, I'm right, thank you.
Now, does this show, Dr. Cand, the predicted noise from the wind turbines with 4 of them operating in a reduced noise mode?
Yes, that's correct.
And what does it show so far as the proposed rating? I say proposed rating curve, I mean the part of it's fixed and part of it's variable depending on wind speed, but what does it show so far as compliance with the rating curve is concerned?
So the black line is this noise limit, or noise rating curve for daytime periods. And the dotted line in red there are or blue, I mean, they're essentially the same. They're the predictions for Greystone now, and they are compliant. They're below the noise limit, the thick black line. So that means that the predictions with the mitigation in place are complying with the noise limit.
Thank you. Move on to Professor Hughes' inquiry report at paragraph 9. Where he says wind turbines are large mechanical devices that produce a lot of noise. Noise includes the rumble from the mechanical core of the turbines as the blades rotate to the swish of the blade tips passing through the air. The level of noise from an operating wind turbine is like being next to a chainsaw. I think you want to react to that.
That's not really a representative comparison. You know, that's really potentially misleading. Really, the noise you would expect being next to a chainsaw in operation would depend on the model, but you would expect something like 80 to 90 decibels in simple terms. That's the kind of level where you would need ear protection. That's why you often see operators using ear protection and operate a chainsaw. The noise level you would have even close to a wind turbine would be much lower, several orders of magnitude lower, maybe 60 decibel, 50, 60 decibel close to a wind turbine. And you could verify this for yourself by going to a site where you can walk next to a wind turbine, and you would see that you could still hold a conversation at these kind of levels with the noise of the wind turbine. And it would be, markedly different from the kind of noise you would have next to a chainsaw. So that's not really a good representation, really.
Thank you. Go to paragraph 19 of Professor Hughes' inquiry report. Which says, following standard practice, figures 1A to C show measured noise level at 3 locations, which he names together with the base noise limit, I'll read that slowly, of fitted background noise plus 5 dB during the quiet daytime period. I want to do 2 points at once. Will you also have in front of you CD 219 at paragraphs 39 to 41? I'm not going to read it all out, but halfway down paragraph 39, a sentence starts. Sorry, my apologies.
219 is what?
That's Dr. Hughes's, Professor Hughes, I've done it again. Detailed critique of the EIAR assessment, yeah. May 22, and paragraph 39. Yeah. Halfway down paragraph 39, a sentence starts, the critical point is that there is a choice between using A, and he's talking about ETSU here, as is clear from earlier on in the paragraph, background noise plus 5 dB, or B, max 35 dB, background noise. Since background noise tends to rise with wind speed, option A is stricter at low wind speeds but allows more noise at higher wind speeds, whereas option B allows more leeway at low wind speeds but is more restrictive higher wind speeds. Probably the best way of doing this is to ask you small bite-sized questions here. Is this an accurate reflection of the advice on ETSU?
No, that's a misunderstanding of the ETSU R97 method.
And if you go to CD 96, which is ETSU, and noting a comment made at the evening session, I was one of the authors, but I have no conflict of interest. If we go to, I think, paragraph 11 of the executive summary on page small Roman 5, Do we see there the recommendation of the ETSU Noise Working Group, which indeed has become the rating approach of ETSU in the final document?
Yes, that's correct.
And rehearsing it briefly, as I understand it, the approach is to set noise limits relative to the background noise plus 5 dB, except in low background noise conditions where a fixed limit is proposed, somewhere between 35 and 40 dB.
That's right. So the paragraph 11 explains the rationale for that.
If you look at page small Roman 9, you'll see two figures. We'll go to the bottom figure, which illustrates the daytime noise criterion. Do we see there the ETSU advised approach to rating, which is you've got the background level of noise, the dotted line, and then you've got above that straight lines at 35 and 40 represent the lower fixed limit and the higher fixed limit. The limit might be anywhere between 35 and 40, or it could be 35 or 40. And then, as I understand it, at the point at which background noise increases to within 5 dB of the fixed limit, the plus 5 alternative limit takes over. Is that correct?
Yes, that's correct. It's not an option. You have to take the greater of 5 decibel of a background or the fixed limit. So, and it's shown in that chart, is that when the 5 decibel of a background part goes below a certain level, it's just set at a fixed level.
All right. And is it the greater or the lesser of those two?
It's the greater of the two.
The greater of the two is the advice. So now could you, having dealt with that, respond to the two passages to which I took you in Professor Hughes's report, paragraph 19 of the inquiry report and paragraphs 39 to 41 of CD 219. Carry on.
Yes, so I think from these paragraphs, my understanding is that Professor Hughes characterizes the advice in ETSU R97 to a choice between two sets of limits. And you can see that, I think, from the charts he's showing either the fixed limit. Actually, if we look at
if you look at following paragraph 19, perhaps.
Yes, following paragraph 19 in his inquiry report.
Is that figure 1A?
Figure 1A.
Figure 1A, that's
yep.
the one.
Yep.
If we look at that.
That shows it very well. So you've got the back. I'll wait to. So looking at figure 1A, we'll see the background curve, which is the black curve. And you've got a limit in red, which is the 5 decibel above the background curve. And that's essentially is Professor Hughes' preferred noise limit.
That's the dotted line.
The dotted red line.
Yep.
And there's the 37 decibel limit, which is the purple line, which he characterizes as the other option. But if you're applying ETSU R97, you have to pick the greater of the two. So when the dotted red line drops below the purple line, it should just remain at the purple line at lower wind speeds.
So actually, if you took the purple line up to about 7.5 meters a second, you can see the point at which the dotted line crosses the purple line. It's at that point that the limit would be plus 5 rather than the fixed line.
That's correct.
Yep. And that would correspond with what we went to in ETSU at that figure. That would be the shape of the curve. Thank you. On to my penultimate point, ma'am. If we go to CD 219 again, in paragraph 4, This is a very quiet area, but Hawley has arbitrarily decided to use a base noise level of 37 dB. It's higher than has been deemed appropriate for such a quiet area, greatly above the alternative base level of background +5 at low or moderate wind speeds. Taking the fixed limit of 37, has that choice been arbitrary in this case?
No, it's not an arbitrary decision. ETSUR 97 provides clear guidance on the criteria you need to consider to determine the limit in the range of between 35 and 40 decibel, and that should be done on a site-specific basis, considering broadly 3 criteria: the number of noise-affected properties, likely duration and level of exposure, and the generation capacity of the wind farm, and the effect of the limit on the generation capacity. So in the EAAR Chapter 10, paragraph, so that's
10.230. That's where it's set out.
10.230, yes, it's
Yeah.
CD12, yeah. So paragraph 10.230, we explained that we considered those factors on the basis that, so in simple terms, the power generation capacity of the wind farm with more than 50 megawatt capacity is fairly large. There are few properties in proximity of the turbines within the area where we need to consider noise effects, and the duration of exposure, the level of exposure, even considering the background levels measured and the difference between the predictions and the background. We've considered all this, and we think 37 decibel is really wholly suitable for that. My view, professional view, for a site of these characteristics, it would not be suitable to impose a limit of 35 decibel at the lower end.
Was this discussed with Scottish Borders Council?
We've agreed the condition with Scottish Borders Council, with the Environmental Health Department, had contracted a consultant to advise them, and it was agreed we followed the right procedures.
Thank you very much. My last question takes us to CD 219, paragraph 28. And this is the question I wasn't looking forward to because I've got to try and understand it. In paragraph 28A on page 7, Professor Hughes discusses polynomial regression to do with the construction of the background noise curve. And he says in the last 10 to 15 years, 8 lines down, it has become standard practice to apply a generalization of polynomial regression known as fractional polynomials, which include the usual polynomials as a special case but allow for more rigorous statistical testing of goodness of fit. And he refers to 2 sources there. Firstly, what is standard practice among acousto practitioners in the wind energy field?
So, based on the advice in ETSUR 97 and the Good Practice Guide, which is CD 9.7, it discusses that at paragraph 3.1.19.
Is that the paragraph beginning, unless there is a,
Yes.
unless there is a specific noise source?
So that's the source of the advice. That's fine. Well, the advice is to use, what I think, is it called classic polynomial curves?
It is standard polynomial curves. because they are available to most practitioners with a basic office software, if you want, and it's a way to standardize practice among practitioners, and it does what we need it to do, which is to provide a typical or average background curve.
Professor Hughes might say to that, and might have some sympathy with his point if he did say it, that that's fine, but you're just using the technology available to you rather than the best available technology in order to derive the best possible curve. This is why I think you produced your extra figure, which we might go to.
Yes, so if we look at CD
1112.
So,
if I may, I will take you through it because
okay.
I want to understand it so that others understand it. So we've got two background noise curves there at, say, 2 meters a second. The dotted curve is that of Professor Hughes based on fractional polynomials. Is that right?
That's correct.
The upper unbroken line is your curve using classic polynomials.
That's correct.
And we can see that the dotted line remains below your lower background levels up to 7 meters a second, where the lines coincide, and then at about between 8 and 9 meters a second, roughly, a bit more than that. The bracket's a bit bigger. His background noise curve goes above yours before it, at about 10.5 meters a second, it becomes lower again. Have I represented that correctly?
That's right, yes.
The two curves at the bottom of the graph are Carcant and Woolmuir. We need not concern ourselves with those for the purpose of this exercise. They can be disregarded. We then have the orange line, which represents the ETSU rating curve based on a fixed daytime limit of 37, translating to +5 at about 7.5 meters a second. You see that?
Yes.
In terms of the compliance with the rating standard, can we see, and we're really only concerned with the +5 bit of the curve here because at lower background noise levels, it's the fixed limit anyway, so it's immaterial. But once you get up to 7.5 meters a second, +5 takes over. And can we see that the effect of the fractional polynomial curve being slightly higher than your classic polynomial curve is that actually the ETSU rating limit increases above that which you're applying in this case for a short period?
That's correct. So we've basically derived the limit with both curves, and that's the black and orange curves. And they're either identical or the alternative curve based on Professor Hughes' background is slightly higher at 8 to 9 meters per second.
So does the use of fractional polynomials in this case make any difference to the compliance of Greystone now with the rating level agreed with the Scottish Borders Council?
Essentially, no. In both cases, if you take the background but apply it in line with the ETSU 97 guidelines, as I've outlined, there is either no difference or a meaningful difference. There's no difference in terms of compliance of our predictions with the noise limits.
Dr. Count, thank you very much for your stay there. Maybe some questions for you.
Thank you very much, Dr. Cand. I'll move to Mr. Campbell and any cross-examination questions you might have.
Thank you. Could you take up
Mr. Campbell, can I get you to switch your microphone on?
Apologise. The applicant has requested that the noise limit be increased to 37. This may appear to be a small increase, but the decibel scale is exponential. An increase in the noise limit of 2 decibels translates to an increase in noise exposure of nearly 60%. For future reference, an increase of 3 is almost exactly a 2 times increase in noise exposure. You were at pains in your answer to make a distinction between the perception of an increase of that kind and actual noise exposure. But what you say here is you're talking about an actual noise exposure, aren't you? Because perception will differ from person to person.
Yes, to be clear, I don't mean. Perception of noise is subjective in nature. Our attitude to noise, to different noise sources varies. But here I'm really talking about the basic perception of noise by the ear. The physical is really the basics of acoustics. So what I mean is that it doesn't really matter your attitude to noise. If I played you a noise at 35 decibel and a noise at 37 decibel, you would struggle to tell which one is the loudest.
I understand the answer that you gave an examination chief, but that wasn't the question I asked you.
Your microphone, Mr. Campbell.
You're absolutely clear in this paragraph that you're talking objectively about the level of exposure to noise, aren't you? Nothing to do with perception.
It's subjective perception, and the subjective perception happens afterwards.
You can't have objective perception, Dr. Cant. I'm 75, Mr. Trinnick's probably 10 years younger, the ladies over there are younger yet. Their perceptions will be different according to the same source. Now, you're talking about an objective increase, are you not, of a given amount?
Yes, it's simply in terms of the relative difference. Our hearing, our ears are all very different, but they all operate in the same way, in this logarithmic way.
No, I'm sorry, I'm still not getting the question home. In this paragraph, you are talking about an objective increase, are you not? A measurable objective increase. The effect it has on any of us will be different, man to woman, woman to man, person to person.
Yes, the perception will be different, but they cannot discriminate as such a difference.
That's not what I asked you. I'm sorry, we have to stick to the question. The perception is not what I'm asking you about. I'm asking you about the objective measure of increase. And that, I think, is what you're talking about in this paragraph.
I think there's a misunderstanding of words here, but the objective measurement, it would be a difference of 2 decibel, and people, cannot discriminate a difference that low in most conditions. And then the subjective feeling about it is a totally different topic. I'm talking about the basic discrimination.
I don't think this is a language problem. I'm sorry, just to go through it one more time, if I may. I may try your patience, but forgive me if I do. You're quite clear in this paragraph that you're using the word exposure, and that, to me, means the amount of noise to which the receptor is objectively exposed, the amount, the quantum. What I make of that exposure, of course, will differ from person to person. Is that fair?
Maybe I'll take it another way. I think.
No, I'm sorry. I must insist on asking that question. Is that fair?
The physical increase is an increase of 60% in energy. That's the objective parameter. There's an increase of 60% in energy,
So the answer is yes.
But the perception, the objective perception.
I'm not asking you about perception. Sorry to keep interrupting you. I'm not asking you about perception. I'm asking you about.
I'll just interject for a moment there. Mr. Campbell, when you are asking Dr. Cand, I just remind you that paragraph 13 is Professor Hughes' authorship rather than Dr. Cand's. So not his words, but
You're quite
Professor
right to remind
Hughes.
me. Sorry. Okay. Is Professor Hughes correct in the third sentence of this paragraph when he says, for future reference, an increase of 3 decibels is almost exactly equivalent to a 2-time increase in noise exposure?
In terms of energy, but my point was that it's misleading because that will suggest that the loudness increase would be 60%. That people would perceive that as a loudness increase. That's the layperson understanding of this paragraph, which is the problem, is that if we're saying it's a doubling of noise exposure, the lay perception of that is that people would perceive it as a strong increase in noise. And I was just clarifying that, no, they would not perceive that as a clear increase in noise.
Sets out his experience in the beginning of the statement. I'm sure you read it. He uses the term noise exposure. I think the answer to my question is yes, that when he uses it, noise exposure, we should understand an objective increase of this amount, A over B, 3 to 6, 6 to 12, whatever it is. I'm not asking about perception, remember. Before you open your mouth, I'm not asking you about perception.
Yeah, that's correct.
Thank you. We turn next, if we may, to the reference you made to the map at KA1. And you appeared to rule out the possibility of the wind blowing from 2 directions at the same time. I think you and I can probably agree about that. We can see the Greystone Knowe turbines in the middle of the map, shown as black dots, and we can see the WIN-140 turbines shown as yellow dots to the northwest. Is that right?
That's correct.
The wind would have to swing through 90 degrees, wouldn't it, over a period for there to be exposure to noise from both locations. The wind could blow from the northwest, but it could swing through 90 degrees and blow from the southwest.
Yes.
If we're looking at a noise exposure averaged over a period, is it conceivable to you that the wind could indeed blow from both directions over the period of measurement?
It's unusual for wind speeds to vary that rapidly, wind directions, to vary that rapidly. But the point I was making was that it would not happen at the same time.
I think we're in agreement about that, Dr. Cand. But if we're talking about an LAEQ, for example, of 8 hours, it's quite conceivable, isn't it, that the wind can swing about?
Yes, but in that scenario, you would have, let's say, over 10 minutes, you have 5 minutes of one wind direction and 5 minutes of the other. They would not add together, they would average out. So they would not...
Certainly, they would average out.
They would not add together.
So the resultant readout... I beg your pardon. You hadn't finished, I'm sorry.
I was just saying they would not add together was my point.
Well, I take that from you. But if we're looking at an average over, let's say, an 8-hour period, we're going to see exposure from both... We're possibly going to see exposure from both directions, aren't we?
That's unlikely. You know, in my experience, you would not tend to get such a rapid change wind directions.
To try to objectify this a little, we would look at a windrose, wouldn't we, to see the predominant directions of the wind over a period, and that's no doubt in the environmental statement. I'll invite you sometime to come and live in the borders, and you'll see how the wind moves about. Okay. I'd like to ask you now about referencing wind speed to hub height. You've explained very well what ETSU says and what the Good Practice Guide says. I'm not sure that you explained how a wind speed measured at a height other than 10 meters is referenced to 10 metres. The figure that you gave us was 10 metres. I think what you were saying was it's a way of comparing like with like. How is the wind from a hub height referenced to 10 metres? Is it just arithmetic, or how does it work?
It's a fixed correction that's applied. It's a fixed correction factor, but it's applied to both the prediction and the reference used for the measurement, so they cancel out. It's a fixed. It's not physical correction. It's a fixed correction that's applied for historical purposes. Appreciate it's confusing, but
no, it's not confusing. Yes, it is confusing. It is confusing. I need to help the reporter understand the means by which wind speed is said to be referenced to a given height, which is neither the height of the hub nor the height of the blade tip. It's a lower height. So first question, why a lower height? Secondly, how do you achieve what is presumably a reduction from measurable wind speed at hub height to 10 metres?
yeah. So I think we need to go to R97, which is CD 9.6. And we go to page 120. And in simple terms, there's a formula. Yeah, sorry, I'll give you some time.
I am actually just about to follow. Excuse me. Don't mind what it'll be on this one, please. Right. For clarity, we're on CD 9.6 ETSU, page 120.
There may be a problem because the CD, I think it only contains the executive summary.
Oh,
Yeah.
I'm on page, I've got,
Have you got the whole lot?
yep,
Yes, I found it.
table 13, table 12. Dr. Cand, is that what you're about to take me to? Yeah, no, I have it in front of me.
Oh, well, what's happened here? I'm just trying to locate it. Sorry to take time.
So what we're doing is there's a formula there. You've asked me the question. There's a formula that's given, and we apply this formula with a fixed parameter of in terms of the parameter Z0, and that's defined in this IEC standard that's used for testing wind turbines. If you want, the aim of that was, if you're testing a turbine that's 50 meters high and another model that's 80 meters high, they would have different wind speed references, but they're all corrected. When you report the noise emissions, they're all corrected with, you apply this formula, and that's a fixed formula based on the height of the turbine, and based on this fixed parameter Z0. And that's how the noise emissions are reported. It's for comparative purposes, for consistency purposes, historical purposes, like we said. So there's no intention to represent a real wind speed at 10 meters. It's that different turbines of different heights, when you give them noise emissions, they'll all be corrected in the same way. And so we have, like, by necessity, we have to do the same when we do the baseline measurements. Otherwise, we'd be comparing apples with pears when we're comparing predictions and measurements of baseline. We have to use the same notional correction.
I'm looking at page 120, electronic page 141, of ETSU R97 under the heading wind shear, just to be sure I'm in the right place. Yeah? And there's a formula there shown in the fourth line. Is that the formula you're referring to?
That's correct.
I don't need you to explain it to me, probably to the relief of everyone in the room. But essentially what I'm taking from your answer is that a calculation is applied to the measured background noise and a calculation is applied to the measured hub height noise from the anemometer.
That's correct. So in both cases, when we're measuring,
excuse me,
in both cases when we're measuring the noise from the emission of the wind turbines, and we apply this correction, and therefore when we measured the background noise at properties around the wind farm proposed in this case, we have to apply the same correction, because otherwise it would not be a meaningful comparison.
But the question was, is that what you do? And I think you've said yes. Okay. So when we learn, for example, that a static microphone in somebody's garden is yielding an average of X decibels, that's actually not a measurement. It's a measurement which has been subject to calculation.
We've corrected the wind speed, not the noise measurement, the wind speed, at in which conditions the background was measured. So if I take you to, if you still have the CD 1112, which is this new curve that was submitted this morning, perhaps I can explain. If we take, for example, a wind speed, so 7 meters per second, you can see that we're predicting a level from the turbines at that wind speed of 37 decibel. And so the question is, in these wind speed conditions, these very wind speed conditions, what was the background noise at the property, in this case, Wester Coulshope? What was the range of background noise experienced? And so when we measured the background, we had a measurement of wind speeds done on the Greystone wind farm site. So these are the wind speed that the turbines would experience in the same conditions. And you can see the background noise varies at that wind speed between 20 and 40 decibels. And so, but we used the same wind speed reference. So we're not correct. We measured what we measured. That's simply factual. But when we say, well, what were the conditions at this time? What were how windy was it? At the same time as we're predicting 37 decibel, how windy was it on the site when we measured the background noise? So we're comparing like with like. So we have to apply the same correction.
So the readouts, which are the small dark circles, say between 20 and 40, where you took us, those are readouts not all at the same time, but at intervals. Is that right?
It's over a period of weeks because we have to capture a range of conditions.
Okay. So there's no time axis on this graph, is there?
No, that's correct. We're just referencing everything to wind speed as the main variable.
And so we have to look elsewhere to know what time is covered by the data shown on this graph. Is that correct?
That's correct.
Thank you. I'd like to turn now, if I may, to the question of reduction of turbine rotation speed as an expedient for reducing noise at a given property. My learned friend took me to Professor Hughes' inquiry report at paragraph 38 and 9 on page 19. First of all, in making use of modern turbines, you talked about variable speed. Does that mean that rotation speed is infinitely variable or only variable by steps?
it's not variable by steps, but it's variable within a certain operational range, yes. So it will vary continuously between something like 10 rotations per minute to 15 rotations per minute, depending on the model.
And how is the rotation controlled, the speed of rotation controlled?
It's a complex matter of how these turbines operate. As far as I understand it, they vary the torque and the resistance of the generator and the pitch of the turbine, which is the pitch of the blades. They vary the angle of the blades against the wind, if you want. So they control all these parameters to vary the power generation and the rotational speed at each wind speed.
Am I correct to understand that when variations are implemented, it's not simply a matter of reducing rotation speed, let's say, by 10% in order to achieve a given noise output, but that essentially to reduce the noise output, it's an experimental trial and error process, because it depends on the receptor?
No, that's not the case. Essentially, the turbine is designed to operate in different modes and along a certain prescribed curve. So in the normal mode, it would operate in a certain way and rotate in a certain way at different wind speeds. And then if set to operate in a different mode, it would operate along a different curve, if you want, of operation, a different mode of operation. So it's not a reactive way, it's simply programmed to respond to wind speed and power generation in a different way.
So alterations to rotation speed, whether by means of the clutch on the generator or feathering the blades, that's all done presumably electronically, controlled from outside the turbine.
It's controlled by the control software of the turbine, if you want.
Okay, that's what I wanted. And it must follow, mustn't it, that if a step is taken to reduce rotation speed and therefore reduce noise, that whether or not that is the rotation speed in the end depends on the perception at the receptor.
I'm not sure I understand the question, sorry.
A complainer complains of too much noise. Steps are taken to reduce rotation speed. The complainer says, it's still too noisy. Turn it down again. And so on until a satisfactory compromise, presumably a compromise, is reached. Is that how it works?
Maybe what would be, in this scenario, this mitigation has been designed to predict it to operate, to result in compliance. So this mode would be programmed into the wind farm. In this case, we would say these 4 turbines operate in a reduced mode in these weather conditions. So that would be programmed in. If someone complained, you would test that. You would test whether this program works or not. You could test that to the planning condition. And if that was not the case, that it met the conditions, then you would operate a different program, a different mitigation mode, and you would retest that to see if it complied. So it's not a direct feedback in maybe the way your question suggested.
What I'm trying to get to and understand properly is it's not a matter of professional judgment. It sounds to me as if it's a matter of taking steps with the software to reduce rotation speed a notch at a time or an integer at a time in order to achieve a satisfactory outcome. And that can be programmed into the operation of the turbine.
Yes, but we're starting from the knowledge of, these modes are tested by the manufacturer, so we have an expected performance. So we can use that to predict the performance. So it's not an iterative process. We would, as we've done here, we would say, well, based on this turbine model, which might be different from the candidate, we'd say, based on this turbine model, we think, based on, rigorous tests of the turbine, that, and the prediction model, that these, the noise limit should be achieved. And so that will be the basis for programming a certain approach. So it's not a case of a test procedure where you would hope for the best.
It's not just a matter of volume, is it? Often. It's a matter of volume and character.
The character does come into play in terms of the tonality is another factor, but in terms of what we're discussing here, which is the noise limit, that is a prescribed noise level that needs to be achieved. So that's purely a question of noise level.
But you know from your vast experience that when complaints are made about noisy turbines, it's not always just about volume. It's about volume and character. I think you're telling us, are you, that it's essential to the... Fair enough. I'll ask it again.
Please.
You know from your own experience that when complaints are made about turbine noise, very often complaints about volume are combined with complaints about the character of the noise.
Yeah, yes.
That's a fair.
That does happen.
Fair. What you're proposing here as an expedient, as a solution or a possible solution, is a reduction in turbine rotation speed to achieve the reduction of volume, but not to change the character of the noise.
That's correct. That's correct. It's a mode of achieving the noise limits set out in NTR 97, which would be the basis for the consent.
And what's your confidence level in your prediction, given that you don't have a selected turbine yet? You have a candidate turbine.
So our experience of measuring, plenty of operational wind farms is that these prediction models that we use are robust. They do work in practice, even when you have these combination of operational modes. We have tested wind farms like this. These levels are achievable in practice. In terms of the second part of your question, this is a candidate model, but we've modeled a candidate which is relatively noisy, based for turbines of that dimension and height and size. So I'm fairly confident that when the final model would be selected, that you would either have a similar or even lower mitigation required, because the noise level of turbines of that scale would be either similar or lower. So I have a good strong confidence that this can be achieved.
Thank you. Which turbines are you postulating should be operated in reduced noise mode? Can I put it to you another way? Are they the eastmost turbines in the assembly?
So, well, first to be clear, we're just giving an example of a mitigation that is predicted to operate. We're not prescribing that will be conditioned or will be the final mitigation mode. We're just showing an example. So the example we took to illustrate that it's achievable is so it's in the technical appendix 10.1, which is CD 1.7, and I apologize for the lack of page numbers, but it's paragraph 5.7.11. And so we're saying that in this example we're saying, for example, by operating turbine 7, 11 and 14 in mode 9 and turbine 12 in mode 10 within a certain arc of wind directions, this would result in reduced noise levels which would be compliant with the noise limit.
Thank you. Does that evidence mean then that you have taken the total likely noise output of the entire array and subtracted sufficient to give you an acceptable noise level at 3 properties? Is that how you get to the figure of 4 turbines?
Yes, we reduced the noise levels from turbines until we obtained a prediction that was compliant with the derived noise limit.
So that wasn't quite the question.
Okay.
The figure that you've given us is 4 turbines, 3 in mode 9 and 1 in mode 10, if I have you noted correctly.
That's right.
Never mind what those modes mean for a second. Does that mean you've calculated the entire likely predictable noise output for the whole array and then subtracted sufficient to achieve a result at a given location?
I mean, not quite. No, we add up the noise from all the turbines.
So I'm right in the first part of my question is correct.
If you want, yeah.
Well, not if I want. I'm not the witness.
Well, I don't quite understand
the question was, have you taken the likely predictable noise output from the whole array?
It's all the turbines operating unconstrained except those 4.
Yes.
Yes.
So how do you get to the figure of 4? Why is it not 3 or 5?
I think it's a simple process. So we start with all the turbines operating unconstrained, and then we turn down. We essentially reduce the noise from some of the closest turbines, and reduce noise from the turbines until you get to. It's an iterative process. So we reduce the noise from these turbines until you get to a total noise level that is compliant with the noise limit.
Right.
There's many different ways you could.
Well, but that's very clear. Your ultimate result, 4 turbines turned down, is a function of the total noise output of the whole wind farm, subject to subtraction. Am I correct?
It's one way of looking at it.
Well, it's my way of looking at it. I need to know if it's correct or not.
The way we have described it, that's correct, yes.
Grateful. It must follow, mustn't it, from that answer that the entire array cannot operate unconstrained without exposing at least these 3 properties to excessive noise?
Not quite, because based on our analysis, this would only be required in some wind directions. So there are some wind directions where the wind farm can operate unconstrained. And in this case, between 45 degrees and 225 degrees, that's when, the noise level, when we account for wind direction, that's when you would have to implement this reduction. So there's some wind conditions in westerly winds, northwesterly winds, for example, where the wind farm could operate unconstrained. And there's other wind direction in which some of the turbines will have to operate with some constraints.
I see. So it's not restrained operation the whole time. It's only part of the time when the wind is in a certain arc of the circle.
That's correct. And certain wind speeds as well. So at higher wind speeds, the noise limit increases and there's no need for restrictions in this case.
Sorry, would you mind giving me that answer again?
Yes. So the excess of the noise limits is identified between 6 and 8 meters per second. So at the high wind speeds, there's no excess of the noise limit, so there would be no need to apply the constraints on these turbines.
So your evidence is that for the candidate turbine, the wind speed range within which restraints must be applied between 6 and 8 meters a second.
As a minimum, yes.
What do you mean by at the minimum? Could it be 5 to 9 or 4 to 10, or what is
It's,
Just trying to help you here with the question. It may be a quicker way to get the answer if you go to CD17, Annex E, figure E5.
I'm sorry, I don't want to do that, Mr. Chair. I
Well,
want to know
it's
what the
trying to
expert
assist to
tells us.
get to a quicker answer, that's all.
I don't want to go to the document. Okay, I want to establish the principle. Okay. Dr. Candy, the principle.
mm-hmm.
You said 6 to 8 meters per second as a minimum, and I want to understand what you mean by that.
Well, that, you know, the operator could choose to operate that in, could choose not to restrict it to that minimum range, but, and so it you know, it doesn't have to operate in that way, but the restraints could be relaxed at these higher wind speeds.
Switch off your microphones when you're not speaking.
The operator could choose, is what you said in the last answer.
Yes, yes, they as long as they operate within the
For that to be clear to an operator, he would have to know, wouldn't he, at a given moment, what the exposure was at the receptor property.
No, like I said, you would program, so in this case, you would program the turbines to operate in this wind speed range and this wind direction range, which you can do in modern turbines. You can say, I'm going to operate in this wind speed range, and these 4 turbines in this wind speed range and this wind direction range must operate in this mode. There's no need to measure. That would be the assumption. Now, they might choose to extend that to be based on the risk they want to operate within, but as a minimum, there's a certain range where they'd have to operate.
How would a receptor, in your opinion, how would a receptor know whether these parameters are being exceeded or not? Yes, of course.
Well, the way this is controlled is through a planning condition, and they would raise a complaint to the local authority, and that would trigger a mechanism to undertake some careful measurements of the noise at the property, and the measured turbine noise levels will be compared with the noise limit.
Forgive me, it's essential, isn't it, to understand how this works, that the receptor is aware more or less instantaneously when the constrained mode parameters are being exceeded.
It's not that simple. These are difficult measurements. In terms of, you've got not just the turbine noise, but other noise sources in the environment. I've shown the noise levels in CD 11.12. This chart, you can see how the predicted noise levels from the turbine compared to the existing baseline levels, and you can see that the turbine noise is within the range of existing noise levels in the area. So it's not a simple way of listening and saying, oh, I can detect a certain noise levels. You have to do very careful noise measurements by specialists. So if you're asking whether a resident would notice whether a level is exceeded, I don't think that's right or possible. I think a resident would hear the turbine noise and make a subjective judgment on that. But if we're talking about compliance with an objective test, which is this noise limit. That would have to be measured very carefully in line with the procedures in the noise limits.
Procedures in the noise condition. If it's
Noise
applied.
condition, that's right.
Yeah. And that would necessitate engaging with the local authority, presumably measuring over time, correlating the results, and then reaching a view.
That's correct.
Yeah. Do you think that's an effective way of controlling exposure to noise?
I think it's the only practical way to do that in reality.
I'll write that down. Thank you. The only practical way. The selection of 37 decibels. You took us to ETSU R97, to the guidance on the limit between 35 and 40 decibels. You explained how that's expressed in ETSU R97. Two questions about this. The document was written in 1996, a little while ago now, and what I want to know is, do you have any reservations about the application of these rules today in 2025?
I'm going to say something. The scope of this session was cumulative noise. We're going well beyond that now in these questions being asked. There has to come a point.
I mean, the question is a relevant one.
Well,
otherwise there wouldn't be an objection to cross-examination, which, as you know, is very bad manners.
manners or otherwise, can you indicate how much further you're going with these questions?
I've got
Mr.
two or
Campbell?
three questions more, and that's all.
Okay. I'm content to hear this line of questioning as long as it's not too extensive. I may stop you at some
The
point.
selection of 37 dB is a matter of agreement between you and the local authority, isn't it?
Yes.
You must have put something to the local authority to persuade them to depart from their normal rule of 35. Is that the case?
Well, as I mentioned in my inquiry report, I'm not aware there is a standard rule that they apply. They did not express a requirement or a general preference for a certain end of this range. I've explained the reasons why we've considered this limit is appropriate. I think it's in line with the guidance in ETSU 97 and it remains relevant.
And to be fair to you, you didn't do the original noise report, did you?
I supervised it.
You supervised it.
Yes.
All right, thank you. So you tell us, do you, that you, the last question, do you, that you applied the criteria set out in ETSU for the selection of 37?
Yes.
Were you aware that Scottish Borders had, prior to that, always applied 35?
I was not aware there's a general rule. They might have
No, that's not what I asked you. Were you aware that Scottish Borders habitually applied 35?
When you say, I mean, they might have done this on other projects, but they did not, in consultation we had with them, there was never a suggestion that that's what the expectation they would have. No.
So I think the answer is no, I wasn't aware.
I wasn't aware of a general rule, no.
I'm not asked a follow-up question, so I don't know what the objection's about.
Making a statement at the end of a line of questioning which rehearses wrongly the answer given.
Were you aware or not that Scottish Borders had hitherto applied a practice of choosing 35 as the limit for noise generation in cases of this kind? It's a yes or no answer, and I think you're saying you weren't aware, but you may be wrong.
Well, I don't accept the premise of the question. It's a site. Each site has to be judged on a case-by-case basis.
Right.
The guidance in ETSU is very clear.
Thank you. I have a careful note of your answer. Much obliged. Thank you. Thank you for your time, Dr. Cand.
Right, thank you, Mr. Campbell. Mr. Trinick, any cross-examination will then move to a short break
Scott, very short question.
Okay, thank you.
You were taken at the start of the cross-examination to the 3 dB increase, and clearly we know that on a scientific and technical level that energy and loudness, there's an equivalence between energy and loudness objectively or technically. And I think you accepted that, didn't you?
Yes.
So I want to be clear that your evidence solely relates to subjective perception of the level difference.
Of the loudness, yes.
Yeah. Thank you. I don't want to go any further on that point. In terms of the wind swinging around 90 degrees, what is the measurement period that you use? The period, is it 10 minutes?
It's a 10-minute period, yes.
10-minute period. In your experience, does wind swing over enough of a direction such that properties could be downwind of both sets of turbines within one measurement period? What's your experience of that?
It's very unlikely of a 10-minute period. The wind, tends to broadly change over the course of a day in the wind direction. Wind speed is much more variable. The wind directions tend to vary more strongly, at least in wind-exposed location where turbines are located.
And finally, penultimately, on tonality, so when we're talking about noise, which is slightly different from normal broadband noise, tonality, is that recognised in the standard conditions, indeed the conditions proposed in this case? Is there a penalty payable for tonal noise?
I don't think there's a question about tonal noise in the cross-examination.
Yes, there was. You mentioned tonality.
No, I didn't. I mentioned character.
The word tonality was used.
I mentioned tonality. It's an aspect of the character of the turbines that is controlled by the planning conditions.
And finally, if you go to CD17 Annex 3, Figure E5,
E5.
yeah, that's the one. Does that help in terms of the questions that Mr. Campbell was asking you about the wind speed range within which a noise mode reduction would need to be made?
Yes, so if you've got it around the figure E5, that shows the predictions of the noise from the wind farm. There's the red or blue dotted line. They sit above the noise limit, the proposed noise limit, between wind speeds of 6 to 8 meters per second. So that illustrates the range of wind speeds where mitigation would be required based on this candidate turbine.
Thank you, Dr. Khan. Those are all my questions.
Thank you all. I don't have any follow-up questions for Dr. Cand, so this is a suitable point at which to take suggested feedback. Professor Hughes gives his evidence in chief. So it's now 15:10 if we resume at 15:25. Thank you. And are moving to the evidence and others of Professor Gordon Hughes. Mr. Campbell, could I ask you to begin?
A little bit of scratches. Can you hear me all right now?
Yes.
Is it working okay? Professor Hughes, good afternoon. Thank you for attending this afternoon and indeed to listen to Dr. Cand.
I will just stop you there. Both mic, it's better if they're not, if you just press it when you're speaking rather than leaving it on. Thank you.
Without wishing to take you through your curriculum vitae, Professor Hughes, if you'll forgive me saying so, it's a long way from the World Bank to Heriot Community Council. How do you come to be here?
First of all, I live in the area. I know the chairman of Herrick Community Council quite well. I have taken an interest in the analysis of noise data for a considerable time, going back more than a decade, and I was asked to provide some advice to Herrick Community Council based on the evidence that had been prepared and submitted by Dr. Khan's colleague.
Thank you, I'm much obliged. You prepared an inquiry report. The reporters kindly agreed that that may be taken as your recognition as well. You have it in front of you, or on screen?
On screen.
Thank you. I don't propose to ask you any supplementary questions about it, and I'd like to tender you for cross-examination, therefore, by my learned friend, Mr. Trinick.
Thank you, Mr. Campbell. We'll give Mr. Trinick a moment.
I'm now ready. Good afternoon, Professor Hughes. Make this as quick as we can, given that some of us have been in this room for an awful long time. If you go to your inquiry report at paragraph 13, oh, I'm sorry. Yes, of course. Right.
Excuse me, could we establish terminology, because I'm not clear enough? By which do you refer in date to inquiry report? The one I wrote in 2022 or the one I wrote in 2024?
2024.
Right.
If you've got the CD references there, I don't know if you have, but your 2024 report is CD 15.6 and 2022 is 2.19. So I'll try and be disciplined enough to refer to them by date. In paragraph 13 of that 2024 report, you say what you're saying. It's been rehearsed already about an increase in noise level of 2 dB translates to an increase in noise exposure nearly 60%, and for future reference, an increase of 3 dB is almost exactly equivalent to a 2 times increase in noise exposure. In technical terms, of course, you're quite right. If you said, based on his own qualification and his years of acoustic experience, including experience in psychoacoustics, he said that to 0.4 decibels to existing noise levels would be virtually impossible to discern. Do you have any counter that of Dr. Khan?
Noise perception is widely varying across individuals. I myself have rather bad hearing. Other people have very acute hearing. I am not a specialist in the perception of noise. All I am aware is that it's extremely variable.
Fair enough. Do you have some follow-up questions on those? I'll have your answer, and thank you. You also heard Dr. Khan say in his evidence in chief orally that because the properties which would receive noise from Greystone and those which receive noise from Woolmuir could not be downwind at the same time, that even the 0.2 to 0.4 theoretical increase in noise would not occur. Again, do you have any evidence on the basis of which you disagree with what Dr. Khan says?
I have nothing to add on the issue of perception of noise. I think there was a different issue about whether they would ever coincide. I'm not sure whether you were asking about that.
Yes, I'm asking if you like, with a concept I call downwind, where you've got two wind farms bearing on a single property downwind of both wind farms. Haven't put that very well, but you heard Dr. Can say actually that can't occur in practice here because of the locations of Woolmuir and Greystone now, and that actually that 0.2 to 0.4 theoretical increase in noise would not occur in practice. You heard him say that.
Yes, and I agree that it is unlikely.
Thank you for that. If you go to your inquiry report, hold on. Sorry, to your 22 document, CD 219, at paragraph 13, it's a point of reference only for the reporter, because what we're talking about here is the question of making sure that you're comparing like with like as between turbine noise and background noise. And you remember that Dr. Can explained that what people do now that turbines are much denser is to make sure you relate turbine noise and baseline noise to the same height, that is to hub height, when making measurements. And there's this notional correction to V10, which probably has no significance to this point, but the basic comparing like with like. Do you have any doubts about that? In other words, do you still think you need a wind shear?
Yes. If I may.
Of course, please.
If I may. The explanation given by Dr. Cand was entirely reasonable if it were exactly what had happened. But the starting point is that in collecting background noise, the applicant did not collect noise at hub height, sorry, wind speed at hub height. It collected data on wind speed at a variety of heights from 10 meters to 80 meters. So what he describes as the process of standardization isn't what happened. There was a prior process by which the data that was collected was extrapolated to 110 meters and then standardized, as he described, to 10 meters.
You're of course quite correct that the actual measurements of wind speed Thank you. You're quite correct, of course, that the measurements of wind speed are extrapolated to hub height using a wind shear correction. Exactly. And then standardised back to V10. If that's the point you're making, you're absolutely correct, and we agree. But when it comes to the acoustic analysis, that you're nevertheless relating wind speeds at hub height, sorry, background noise relative to wind speeds at hub height to predicted noise at hub height. You understand?
I accept that it is the intention of the analysis to do that. I do not accept that that is what the analysis has done.
Is that because of the measurement at lower heights and the extrapolation to hub height, you think that the wind shear correction was wrong?
It is variable. The crucial issue here is that what we are trying to achieve is an idea of what the wind speed, what the noise level close to ground level is for a range of wind speeds measured at hub height. To do that, if we were to measure the wind speed at hub height, then the process is, as I described in my original report, a purely mechanical, mathematical one. Because it was not measured at hub height, it is based on what has been referred to as wind shear, and wind shear is extremely variable according to the variety of conditions. So there is not a one-to-one relationship, and that is what plays a core part in the later analysis.
We'll have to leave the difference there between us. Our evidence is clearly that a correct extrapolation is made between the measurements of wind speed at whatever height the wind speeds were measured and hub height being extrapolated correctly and then standardised down, applying the correction, the notional correction to V10. You say otherwise, fine, that's the difference between us.
I don't think that was a question. I think that was a statement, and I don't disagree.
Question mark, yes, thank you, we're done. Looking at paragraph 38 of your 2024 report.
Sorry, did you say 38 or 28?
Paragraph 38 of your 2024 report. I'm trying to get to another page, hold on. You reach a conclusion that for Wester Corsope and Corsope Farm, the use of a turbine mode 9 reduces the frequency with which a proposed noise limit of 37 dB is exceeded, but doesn't alter the conclusion for many periods over 50% of Wester Corsope and over 25% of Corsope Farm. The noise threshold of 37 dB will be exceeded. That tracks back to page 15 of the same report. That's paragraph 37, where you introduce your figures 3A to 3C. And I just want to be clear, because we've already covered wind shear. Are these wind shear corrections that you make in these figures?
Yes.
They are, thank you. Well, we've already covered wind shear, so I needn't go further on that.
If I could interject with a quick point, does that apply to each of the three figures?
Yes.
3A, B and C?
Yes.
Thank you.
Now, you show what you show in your figures 3A, B and C. I want to take you to CD17, which is the Environmental Noise Assessment Report in the Environmental Statement. You've got that, excellent. And go to the last, almost the last page of Annex E. We've already been there. We can see there turbine noise with some operational mitigation applied to 4 of the turbines, and that's been discussed between Mr. Campbell and Dr. Cand. In relevant wind conditions, such the predicted levels would meet the derived noise limit. Now, I know you don't agree with the proposed noise limit, I understand that. But are we in agreement that that is exactly what the figure E7 shows? It does show compliance using a reduced noise mode. I'm not saying it's mode 9, I'm not sure what mode it is, but applied to 4 of the turbines.
Yes, that's what that figure shows.
Fine, thank you. You mentioned mode 9 at paragraph 38 of your 2024 report. I just think, what is mode 9?
Mode 9 is, excuse me, mode 9 is one of the low noise operating modes for the turbine. You've been given some evidence on how turbines achieve lower noise by reducing the rotation speed. There are actually only a limited range of options that they can do that, and my recollection is that mode 9 is the quietest operating mode for this candidate turbine.
Indeed, thank you for that. Now, you heard Dr. Cowan say that reduced noise modes have been a feature of variable speed turbines for a number of years.
That's correct.
Are you familiar with that yourself?
Yes.
Okay. And you've also heard Dr. Cowan say that having done not only predictions of noise, but done measurements of wind turbines in practice, that reduced noise modes work so as to achieve the results predicted. Do you have any evidence on the basis of which you can disagree with Dr. Cowan?
No, the turbine manufacturers certify certain noise levels for different operating modes. There are standard certification processes.
That's a fair answer. Paragraph 9 of your 2024 report. This is the chainsaw point. You heard what Dr. Cowan said in response. Do you want to come back on that? We're a bit surprised by that evidence.
Ma'am, I think how loud a turbine is depends on how close you are to it.
So
I think he was saying that
carry on.
You wouldn't be plausibly close enough to hear it at that level. Probably not. But the point is, if you are close enough to it, in terms of noise emissions, it is the noise emission of a turbine in these modes that we're talking about is up to 106, 107 dB, which is, as Dr. Can said, louder than a chainsaw.
I'm sorry, it's not what the Dr. Can said. He said that if you stood at the foot of a turbine, you'd be hearing about 60 dB. There may be a noise source of 104 to 109 at hub height, but at the foot of the turbine, his evidence was that you'd be hearing about 60 dB. Do you remember that?
No, I don't recall him saying that.
That's what he said. Are you saying, my apologies, my question is that the level of noise from operating wind turbine really is being like standing next to a chainsaw? Is that what your evidence is?
My evidence is that the level of noise emissions from a turbine is much greater than that of a chainsaw. We're talking about noise emissions, not what we hear at the bottom of a turbine, which is 110 metres away.
Yes, it's the way you phrase your paragraph 9, which may be what's between us. It's like being next to a chainsaw. We can accept that the source power level is about 109. Would you accept Dr. Cowan's evidence at the foot of the turbine you're hearing about 60 dB?
Sorry, I have no reason to dispute that.
Thank you very much. If you go to paragraph 39 of your 2024 report.
Apologies, Mr. Trinick, which paragraph number?
I'm not sure actually I got the right one anyway. Can you bear with me?
Yep.
Yeah, but I think I've got the wrong reference. It's your 2022 report at paragraph 39. I'm going to find the other reference quickly. Yeah, I found the other reference. I had the wrong number down. The other reference is in your 2024 report, paragraph 19, not 39. Now, what you're dealing with here is the rating level. And in paragraph 19, you apply a base noise limit of fitted background noise plus 5 dB. If we turn over the page, we can see that applied on figure 1A. In paragraphs 39 to 41 of CD 219, you have some more to say about the choice between using background plus 5 or a maximum of 35 dB. Now, you've heard Dr. Khan take us to ETSU and to what is advised there about the noise limits which are appropriate. That is to say, the greater of the lower fixed level, which is between 35 and 40, and 5 dB over background. You remember that? Yes. Would you accept that that is what ETSU advises? You may not agree with it, but that's what ETSU advises.
ETSU gives a range from 35 to 40 dB, that's correct.
Not quite what I said. I asked you, would you accept that the rating advice within ETSU is that you should stick to the greater of the lower fixed level, somewhere between 35 and 40, or plus 5 above background level? That's what it says.
I'm sorry for my hesitation in replying. The issue is that is the main summary. I accept that that is the main summary. I do not accept that it is quite as simple as that in the body of ETSU.
Do you want to take us to anywhere in ETSU which says something different? It may be a struggle, but you can if you want.
Since I don't have the ETSU with me at the moment, I think there is more of an issue of a logic here. If it is reasonable to increment background noise by 5 dB over some range, then from my point of view as a data analyst, that would apply in logic across the board rather than just for a particular range where it is above 35 or 40 dB. So it is my view that there is a tension within ETSU between the idea of background noise plus 5 dB and the idea of a fixed minimum, whether that be 35 or 40.
So, Professor, the paragraph 11 in the executive summary of ETSU, do you have that in front of you?
No, but I accept what that says.
And that is the advice of the Noise Working Group as to rating levels. The greater of the fixed level, whether it be sub 35, somewhere between 35 and 40, and 5 dB above the background level. You know that's the advice of ETSU.
I know that that's what's in the ETSU summary. I'm saying that there is a deeper logic here. I don't accept that the summary entirely represents the larger logic.
Well, I'll leave that to submissions. I'm not going to go further into that. If you go to your figure 1A, which is follows paragraph 19 of your 2024 report, based on what we've just discussed, you've not taken the ETSU approach, you've simply used 5 dB above background, point 1. I'll ask you that first and then go on to the second question. That's what you've done, isn't it? Your dotted line just follows background all the way up the curve.
that dashed line is background noise plus 5 dB.
Yep. And then you've shown us the purple line, which is the proposed noise limit. That is incorrect, isn't it? Because it fails to record that once that red dotted line crosses the purple line, the rating level changes to 5 dB above background. You see that?
Yeah. Yes, I'm sorry if I gave the wrong impression.
No, it's okay. You need to apologise. Excuse me, ma'am, I'm going through some of my questions, which are probably unnecessary at this stage. So. Yes, the choice of 37 dB, you've heard Dr. Cairns' evidence on that. Do you accept that this was not simply an arbitrary choice by Hawley, but the result of the application of the three factors to which Dr. Cairns referred: duration of exposure, the number of properties to be affected, and the consequences of power generation, and the discussion with Scottish Borders Council, who agreed to 37 dB. As a matter of fact, do you accept that that is what happened?
I simply don't know what happened, so I can't comment.
Fair enough. Then you don't know it was an arbitrary choice, do you? Then you don't know it was an arbitrary choice, which is the claim in your evidence.
I don't know that it wasn't an arbitrary choice.
All right.
That is convenient.
I see. Going to the extra figure, which mine's for some reason in portrait form, which is not very helpful. The landscape format extra figure CD 1112. First of all, do you think that this is a fair representation of the difference between your derived background noise curve based on fractional polynomials and Dr. Cairns' derived curve, so far as you can tell?
So far as I am able to tell, it seems accurate, but I have no information beyond that.
Dr. Cairns, assuming that is correct, and I'm not going to make you say yes or no to that. You've probably had enough time to look at this figure, but you heard Dr. Cairns take us through this figure, and the question I want to put to you is, do you see that actually the use of fractional polynomials, using the ETSU approach to rating rather than just +5, makes very little difference in the end to the rating curve?
Correct.
That's fine. Thank you for that. And that, ma'am, takes the end of my questions. Thank you very much.
Thank you very much, Mr. Trinick. Mr. Campbell, do you have any questions for re-examination for Professor Hughes?
I did have one, ma'am, but I'm lost in my writing. Bear with me.
I'll give you a moment.
Bear with me a second. No, thank you.
I myself don't have any further questions for Professor Hughes, so on that basis we can conclude the evidence in this inquiry session into noise. I would thank both Professor Hughes and Dr. Cand for their evidence. It was clear and of much assistance to me, and will be in writing my report, particularly on this topic on noise. That, therefore, is the conclusion of our oral sessions in this inquiry. I do have some brief closing remarks. Which initially relate to closing submissions in writing. I'm not sure if you received the revised timetable. That should have been circulated today from Christine. If not today, it will be with you very shortly. Those are the agreed dates for the parties, relative dates for closing submissions. If those could be adhered to, that would be much appreciated. Accompanied site visits. Those will be arranged. All the relevant parties will be consulted about a mutually convenient date and itinerary. There will be also a case update on CMS so that all parties who are interested can see what is happening. My unaccompanied site visit to a comparable operational wind farm to view aviation lighting in situ will also be advised to all parties. And yep.
We did talk about Cross Dykes Wind Farm. We probably will be asking you to go somewhere somewhat closer to Crystal Rig Wind Farm, where there is a test light with automatic dimming that was put up for the purposes of the Crystal Rig 4 inquiry. It's still there, apparently. It's still operating. Why, I don't know, but it's still there anyway. And that light has already been used by Karen Haywood for the purposes of a site visit, and therefore we have already determined locations from which it's appropriate to see the light. Okay. So that may well be our invitation to go and see. I mention it in case anybody has any objections to that, so they're forewarned.
No, Mr. Chinnick's not for the first time taking the words out of my mouth. It happens to be quite near where I live, and I can confirm that it is still there. It's a single light, a single installation. Just for the sake of completeness, there is lighting at Middleton Wind Farm, which is near Uplow Moor, and there's also lighting at Neilston Wind Farm. The problem with those installations is that they're a different kind of lighting, and the turbines are different sizes. So I don't think personally, but it's of course for you, that they would really assist you. I've done a little bit of private research. I've not been able to find any other installation in Scotland which has got comparable equipment. There's some evidence in one or two of the East Ayrshire inquiries about the type of lighting that would be installed, but it's not been clear from the applicant's evidence here that we're really talking about the same thing. So I'm not troubled you with that.
I'll wait and see what you submit about Crystal Rig. If the test light is there and operational, then and it meets it's comparable in technical terms to what's proposed here, I'm happy to go and view that. Again, we will advise all parties and consult before we determine exactly which one I'll go and look at, and the case update on our CMS system will reflect that. Before we finish up this evening, I would say a big thank you to Stuart for his assistance this week. It's much appreciated. Very difficult to run any kind of hearing or inquiry without the input of the IT department at DPA, and also a thank you to Christine Brown, our case officer, for all of her administrative assistance during this process. Unless there are any final remarks from any party, it simply remains for me to thank you all for your participation this week. It is much appreciated and will be of huge assistance to me in writing my report. The efforts you have all put into both your evidence here and your written submissions is much appreciated. So I will formally close the inquiry for Greystone now, DPA reference WIN-140-9, and safe travels home. Thank you again.
Thank you, ma'am. May I just, not on our own behalf, but also I'm sure my learned friends, Mr. Finlay, Ms Crawford, and the other participants would join me in thanking you for the conduct of this inquiry, which has been uncommonly courteous on all sides. I don't, of course, speak for Mr Trinick, because he can speak for himself, but I'm sure he would join me. It is very refreshing to have so much evidence covered in a short time, and I think we all understand the investment in prior reading that demands of you, so we're most grateful. Harriet Community Council would like me to join you, I think, in thanking Christine, the case officer, Stuart, Miss Amy Howard for faultless document lists. That's a big deal, because we're not all as good at it as she is. And of course to yourself. Many thanks.
Thank you very much, Mr Campbell. I should have mentioned Ms Howard, actually, and the excellent document management, which does make this process infinitely easier. Much appreciated, Ms Howard. Thank you.